for to be mentioned case item 10, civil will be 118 of 2025.
Yeah, I don't know. So the number 118 of 2025 this matter has been listed at the instance of office. It has been pointed out that the case has been by all and error has been pointed out in order dated 28/11/2025, wherein in paragraph 2, the next date has been mentioned as 3/1/2026 instead of 9/1/2026. There is the records. The order dated 28/11/2025 is modified, and the next date in the matter, as mentioned in paragraph 2 of the order, is directed to read as 9/1/2026. Office to paragraph 6 of 9/1/2026.
This case item 2, first appeal 124 of 2023.
I'll start from section 34, which my learned friend has stressed upon. What would be the effect of section 34? Because according to their case, because we had not sought for consequential relief of recovery of possession, therefore my suit was not maintained. This is essentially what he has argued. Now my contention would be that if I am already in possession, so I was not required to seek additional relief of recovery of possession. So my basic case itself in the plaint is that I am already in possession. The fact that I was in possession is not in dispute. Whether the possession was transferred from me to them is in dispute. So it is for them to show that on which date the possession was transferred. My suit is that for declaration that the sale deed is a void document, and this may be declared. So this would come under section 34. So once it comes under section 34, this declaration which I am seeking, there is a proviso on which they are relying. It says that provided that no court shall make any such declaration where the plaintiff on being able to seek further relief than a mere declaration of title omits to do. So this omission could have been only in a case where I was not in possession. So if my contention is that I am in possession, this proviso would not come in way of granting me the first relief of declaration of that the document is a void. Now, because possession has been time and again is the main point on which they have harped upon, you Lordship may kindly see that what they are relying upon is only the deed by which it mentions that the possession has been transferred, nothing. Because prior to that, admittedly I am the owner, I was in possession. And by virtue of that recital which is there in the sale deed, they say that they came in possession. Now, one thing is for sure, that the deed which also mentioned that this is the consideration amount which is being paid, it mentioned that it is being paid, that has not admittedly not been paid in the manner which was stated in the deed itself. So how can the defendant rely on the clause of the same sale deed, a portion of which they themselves have not complied? And apart from recitals of the sale deed, no evidence whatsoever has been produced by them to prove their possession.
Even older.
No, no. They only say that I am in possession, that is all. But we have also said that we are in possession. Now, mutation, interestingly, mutation was also not done. It is their own case that mutation has never been done. It was not done, and the defendant, who was examined as TW1 in para 23, himself says, cross-examination, that no mutation was done. Now, subsequent to the execution of the deeds, because prior to that I was admittedly in possession. Now, what happens subsequent to the execution of deeds? Your Lordship may kindly take up exhibit once more. Only few exhibits are not place. Only my documents.
Exhibit 1.
Yes. After the sale deeds are executed, then your Lordship may see exhibit 2. And this series of exhibit 2 would itself go to show that they were not in possession.
Exhibit 2.
Exhibit 2 is dated 22/2/2014. This is after the first sale deed of 7/2/2014. And 2 and 2/1 and 2/2 are related to the first sale. That means 7/2/2014. Now the sequence is, your Lordship may see exhibit 2. It says that this is being written by the defendant himself, although my learned friend tried to dispute this document, but it was not disputed in the pleading. So this has to be taken as it is. आप सत्य मोहन राजू जी नमस्कार, आपको यह सूचित करना है, जैसे हम लोगों की बातचीत हुई, आपने अपना जमीन जो मौजा स्वयं थाना सुंदरनगर की जमीन दलील के माध्यम से मुझे रजिस्ट्री की गई। हम लोगों को तय था कि म्यूटेशन होने के बाद ही तयशुदा रकम आपको देना है। इसका चेक भी दलील में अंकित कर दिया गया। लेकिन जब हमने अंचल अधिकारी के पास म्यूटेशन हेतु दलील को पेश किया, यह पता चला कि संबंधित खाता प्लॉट नए सर्वे में सरकारी जमीन घोषित हो चुकी है, म्यूटेशन नहीं हो सकती है। पूर्व में भी इसकी जानकारी फोन के माध्यम से दी है। हमने अपने स्तर से काफी प्रयास किया, अतः आपसे निवेदन है कि मेरे द्वारा दिए गए सारे चेक को हमें लौटाने की कृपा करें और नियम संगत दलील को रद्द करने की प्रक्रिया करें। Then the next 2/1. सत्य मोहन जी राजू जी नमस्कार, दिस इज डेटेड 28/3/2014। मैंने दिनांक 22/2/2014 को पत्र के माध्यम से आपको सूचित किया था कि आपके द्वारा लिखे गए दलील को आप रद्द करते हुए मेरे दिए गए चेक को वापस कर दें, क्योंकि आपकी जमीन पर मेरा कोई काम नहीं हो सकता है, कोई काम नहीं हो सकता, लेकिन बाध्य होकर मुझे आपको पत्र लिखना पड़ रहा है। Then he again reiterates that please refund me my return me my check, and that is returned by way of exhibit 2 by me. So there was absolutely no claim of possession. He only says it is a vacant land, and as I had said, it is a vacant land when he says that no mutation can be done. So therefore, the mutation, the property which stood, which was mine, I was in possession, it never transferred to them. Second is the recital of the sale deed itself. Because you look at these lines would again fall for consideration of what with regard to two other aspects. First, what could be the consequence, whether it would be void or not, and whether the payment of consideration amount was the basis for the sale deed itself or not. This is exhibit, the first exhibit 1, 7th day of February 2014. Para 1 itself, one paragraph itself, it would be absolutely that in consideration of the said sum of rupees 62 lakh 70,000.
Let me just come here.
Yes.
Para 1.
Para 1. It is
I can tell you.
internal page 9 of the sale deed. In consideration of the said sum of rupees 62 lakh 70,000 only paid by the purchaser to the seller as per mode of payment herein below, the receipt of which the sum the sellers hereby admitted and acknowledged as full, final and highest consideration of the schedule below, the sellers by these presents do hereby absolutely sell, convey, transfer all that is mentioned in schedule below in favor of the purchaser by this deed of sale to have and to hold the same unto the purchaser, his or her successor, so and so, with all the right title and possession without any interruption from the side of seller or any person. So therefore, your Lordship, payment of the consideration amount was the most essential part of the entire transaction. It is only after recording that payment has been made, all these rights would accrue to the defendant. And the subsequent paragraph also, that the sellers have delivered possession of the scheduled below land to the purchaser. From this day, the purchaser will possess and enjoy the same as absolute owner in all possible ways, with power to dispose of the same in any manner he likes, and the purchaser shall be at liberty to get his name mutated in the office of the landlord of state of Jharkhand through CO so and so and pay. So why these two clauses I am referring to is para 1 and 2. Now your Lordship may kindly turn to the recent Supreme Court judgment of 2005 which were played. Absolutely identical matter was there and identical circumstances were there. Therefore, in that case also, these lines were there. Then also, it was said that this cannot be denied. So evidence against that can be looked into by the court. Merely because it is entered into in the This your Lordship 2025 SCC online.
Have you given it?
We have placed, we have already given. Shanti Devi versus Jagan Devi. Shanti Devi Jagan Devi. Now fact is very important. Para 5 your Lordship may kindly take note of the fact, because this was also a deed which was in challenge by the same person who was executed of it. And what was the prayer? The plaintiff instituted civil suit number so and so in the court of senior sub-judge Gurgaon for permanent injunction restraining the defendant from interfering with their peaceful possession to the extent of 1/3 in so and so and so and so, all these description. In the alternative, the plaintiff prayed that they may be put in possession along with the defendant, and the sale deed dated so and so 1973 purported to have been executed by Ram Sharan and the plaintiff in favor of the defendant be declared as fraudulent, concocted, thereby void insofar as the share of the plaintiff is concerned. This was only a declaratory relief that was claimed by the plaintiff, who was said to have been the executant of the.
They were seeking possession also in the alternative.
In the alternative it was. But essential relief was, here we are not seeking possession. So the first relief was to please declare it as void. That was. And then para 9, it says that ultimately the suit was dismissed by the trial court. Plaintiff preferred first appeal was allowed. Then para 11, the second appeal, then it was dismissed. So first appellate court was it is there in para 11.
Yes, I see.
First, yes. Then relevant consideration, directly your Lordship kindly turn to the where it takes note of cable creation and thereafter cable creation is mentioned in para 30.
30?
34. This is the one of the main judgment.
Yes.
34. And relevant portion is at it starts from page 34. Then relevant portion is in the next page. After the sale has been defined, sale has been section 54 has been quoted. Then your Lordship may kindly see next page after quoting section 54. Next paragraph after the section. Hence, a sale of just after the section.
Hence a sale.
Hence, a sale. This is cable creation because this is the most important lines of paragraph. Hence, a sale of an immovable property has to be for a price. The price may be payable in future. It may be partly paid, and the remaining part can be made payable in future. The payment of price is an essential part of a sale covered by section 54 of the Transfer of Property Act. If a sale deed in respect of an immovable property is executed without payment of a price, and it does not provide for payment of price at a future date, it is not a sale at all in the eye of law, if it is of no legal effect. Therefore, such a sale will be void. It will be not affect the transfer of immovable property. So, why I am placing first this particular line? It does not distinguish whether I have executed or whether a third party has executed. The moment there is a transfer which may be without consideration, irrespective of the fact that whether the plaintiff has executed the deed or a third party has executed, if it is without consideration, it would be void. The moment it is proved that it was without consideration, the deed would be void. And then, our own this particular judgment itself which I had cited, para 35 and then 38. As far as the facts of the case are concerned, the plaintiff specifically averred that she never obtained any sale consideration from the defendant. On this aspect, the plaintiff reads as follows: that the plaintiff never bought any sale consideration of the alleged deed, and she came to know about this fraudulent transaction when it came to so and so, so and so. Then para 38. After 5 lines, but I'll read entire, but the relevant portion is at 6 to 8, 7 lines after para 38. Concurrent findings of both the first appellate court and the High Court indicated that the husband of the defendant, one Bhagwat, who had allegedly given remaining sale consideration of rupees 6,000 during the execution of the sale deed, had not stepped into the witness box. Furthermore, one of the attesting witnesses to the execution of the sale deed, the Sarpanch, had also died before his deposition could be recorded. One Buthu, who was the second attesting witness, was the brother of the defendant, and both the courts had doubted his testimony as being partial to the defendant. All in all, here I am denying, all in all, there was no witness who could substantiate the case of the defendant that there was part payment of the sale consideration, that is rupees 6,000 during the time of execution of the sale deed. Furthermore, no evidence was adduced by the defendant to prove that even the initial amount of rupees 9,000 was purportedly paid before the execution of the sale deed was actually received by the plaintiff. Therefore, the averment of the plaintiff in the plain that she had not received the sale consideration has not been otherwise proven to be false. In such circumstances as well, that is, in the absence of sale consideration being tendered, the sale deed would be void and the plaintiff would not be required to seek its consideration. So these are the lines on which I am. And then it says, the first appellate court has rightly observed that the plaintiff had claimed the relief for joint possession. It also arrived at finding that the transaction in question was void. To put it simply, the eyes of law, the plaintiff could not be said to have executed the sale.
Are you seeking a declaration of title?
Of a legal status that the deed is void.
Some section that
Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may, in its discretion, make therein a declaration that he is so entitled, and the plaintiff need not, in such suit, ask for further relief. Provided that no court shall make any such declaration, but the plaintiff being able to seek further relief than a mere declaration of title omits to do so.
So in a case where a document is thought to be declared as void, are you seeking a declaration of title?
No,
Then how does this proviso come into
it proviso, because they are relying on that proviso, that where there may be a case, there may be a case where because it also says,
let us take a very extreme case. A person who has executed the sale had already expired on the database. And the person goes and seeks a declaration that the sale is void or its non-execution by the person concerned. And it stands admitted that he had expired by whatsoever reason it may be. Is it necessary for him to seek a declaration of to seek possession, even if the possession was not there? Is it necessary? Because he is not seeking declaration of title. When the very document itself is sought to be declared as void, then all the consequences would follow.
all the consequences, but even under a void document, this argument, even under a void document, if someone is in possession of a property, then I am required to seek that. I am required. I cannot simply ignore that and say that no, because what would happen, that why this particular proviso is there in section 30? It is because no fruitful purpose would be solved by merely declaring someone as a title holder or declaring someone's deed as a void, but someone else is in possession of the property. Then it would create unrest, whatever anomalous situation in it. Therefore, that this section 34 is there, only to prevent that.
What else do you want to know? In response, the Learned Counsel for the Appeal has referred to section 34 of the Specific Relief Act and submits that admittedly no prayer for recovery of possession has been made in the claim, as the plaintiff remained in possession of the property. Since the plaintiff was in possession, the proviso to section 24 is not impacted, and therefore the suit was not hit by section 24 of the Specific Relief Act. We also submit that the fact that the plaintiff was in possession was not in dispute, as the plaintiff was the owner of the suit. It was for the defendant to plead and prove the exact date of possession. He has further submitted that the only material evidence which has been brought on record with regard to possession of the defendant is the sale deed itself. We have submitted that admittedly the consideration mentioned in the sale deed was not paid, as the checks mentioned therein was not paid, and therefore the defendants are not permitted to rely on the sale deed itself to claim that they were in possession of the property. He has referred to paragraph 1 of the sale deed to submit that the one and two of the same. To submit that, the entire consideration amount was stated to have been paid, and the seller was said to have delivered possession of the suit property and since the consideration itself was not paid, the defendant cannot claim possession. The learned counsel has referred to exhibit 2, 2/1 and 2/2, and he submits that even as per these exhibits, the defendant had indicated that the property was not capable of being mutated in their name, as the property was declared to be a government land. And the vacant land was of no use of the defendant. The learned counsel submits that the payment of consideration was the most important part of the transaction, and only upon payment the right would accrue under the deed. Since there was no payment, therefore the sale deed was modified. He has then reiterated the judgment which was cited by him, which is reported in 2025 SCC 19 SC 1961. And have submitted that the earlier judgment passed in the case of Keval Krishna was duly considered in paragraph 54 of the judgment. And has submitted that it has been held that if a sale deed in respect of an immovable property is executed without payment of price, and if it does not provide for payment of price at a future date, it is not a sale. Submits that as per the sale deed, the price was paid, and in fact, the consideration was not paid.
Undisputably, it was not paid in the manner stated in the
Not paid in the manner stated
in the sale deed.
आपकी प्लेन्स में क्या है?
हाँ, please.
आपको पेज मिल गया है, हमको इंटरेस्ट
हाँ।
दो चीज एक बार बताइए तो 34 का आर्गुमेंट आपको सुनना
Because in the Ware Act itself, you would find there are certain judgments which have been mentioned that it is not exhaustive. That means the declaratory relief which is being claimed, if you would see this, Ware Act itself, those have been mentioned. Ware Act में है मतलब reference है to other judgments.
peculiar way of citing a judgment.
नहीं
कौन सा judgment?
ये सिर्फ
कौन सा judgment बनाना है?
the section, because your lordship's query, just section 42 or so and so is not exhaustive of cases in which declaratory relief may be made and the courts have the power to grant such a decree independently of the requirement. That means not necessarily it has to be a case of title itself. It can be other declarations also. This is only one.
Let's see the page once again.
Yes.
These are the relevant paragraph for the position.
With regard to only possession or
With regard to the position.
possession is para 15. That it is mentioned here that the possession of the scheduled land as mentioned in schedule 2 and 3 was not delivered to the defendant by the plaintiff, although he had handed over the registration slip to the defendant on the basis of earlier checks received by the plaintiff. And then another paragraph is para 16 and 22 also. The plaintiff 16 and that the plaintiff state that the two registered deeds so and so executed in favor of so and so defendant has no legal value in the eye of the law because sale consideration was not paid to the plaintiff and delivery of possession were also not given to the defendant even after registration and execution of the registered sale. And then 22 we say that we have given it to some other person, but that may be irrelevant. Here my possession, it was even after the execution of the sale deed, it was with me, is there in para 15 and 16. And this has been replied by them in para 11 of their written statement. That with regard to statement made in para 14 to 17 of the plate, it is submitted that the plaintiffs voluntarily gave the registration slip in respect of the two sale deed and also delivered physical possession of the import land mentioned in the schedule of these two deeds. So the defendant collected the original sale deed from the registration office on the completion of registration of the same, and further the defendant applied for mutation of the land demised by these two sale deeds. As mentioned above, having received the full consideration money on those two sale deeds, the plaintiff are stopped from challenging the validity thereof. That para 12 also, I'm just reading because my logic says that. That with regard to the statement made in para 18 and 19 of the claim, it is submitted that repudiation of any agreement of sale by defendant is totally baseless. The plaintiffs have not disclosed particulars of agreement for sale, having received the full consideration money according to their own requirement and direction in lieu of the encashment of check mentioned in sale deed. The plaintiff has stopped from challenging the validity of the sale deed or to speak or return of the two sale deeds to them. Accordingly, the notice of the plaintiff was replied properly by the defendant. The defendant, having paid full consideration money as per so and also taken physical possession of the suit purchased land, there is no question of cheating anybody. So this, whatever payment they themselves say, this is admittedly or undisputably it was not done till the last date of letters are already there. The letters are Exhibit 2 series.
14 is important in addition on possession.
15/6/2014, there is no mention that this is the last letter which was written by them to us. Please return my check. And the checks were returned. Treating the sale deed itself to be absolutely no transfer was effected by the LC. It is the plaintiff's own, defendant's own contention.
What is the meaning of the land mentioned in Schedule 4 was never in possession of the plaintiff?
Schedule.
Plaintiff handed over the possession.
The edition is reading
Para 14 you just referred to that. Was never in possession of the plaintiff.
it's qualified by the next sentence. So your edition is right in noticing. The standalone it makes an absurd reading. That Schedule 4 was never in possession of the plaintiff. It speaks about it. The major part of Schedule 4 is in possession of the defendant since the execution of the restriction that two sale deeds in question. In fact, the qualifying sentence also answers your pointed query as to what is my case with regard to the point of time since which I am claiming possession. So this was and is subsequent to that. It can be nobody's case that before that date it was not in their possession.
One thing I'll apologize, Your Lordship. One judgment, Rashal Devi, which I had relied upon. My fault. एक print, if Your Lordships. Ashal Devi had relied on in some other case, therefore. This is 2003 volume 12 SCC, page 219. Ashal Devi. This was a case where how a vacant land, whose possession would be there, how it would be considered. Who's been placed?
That's contrary to his own case, which means there is nobody in possession. He says that he is in possession. That will be applicable your edition with respect when parties are saying that nobody is in possession, therefore title will decide who should be deemed to be in possession.
This was a case where
Then nobody is in actual possession.
mutation was done after the sale, but it was a vacant. So in our case, what has happened that both parties only orally they say, and it is there in the pleading that we are in possession. But in effect is that
Any evidence of the ongoing construction over the property?
we have said that we are constructing, but no evidence has been brought.
You have brought.
And I have said that the construction is done by me. That's
Construction is?
done by me. That's what I was saying. Both parties claim the same thing. So the adverse inference would be drawn against the party who would fail if no evidence is given by either side. And therefore their omission to seek a local inspection would inure against them. I'll answer. I'll just take 2 minutes to revert what we are saying. Do it side by side. The very next sentence in paragraph 14, which your edition was seeing, says the defendant is raising construction of the buildings in schedule 2 at the place.
Therefore, your Lordship, I had relied on this exhibit 2 series. 2 series, it never says that we are in possession, and because entire transaction itself was said that we are there is no transaction at all, and therefore they sought return of their own sale.
You raised this judgment? Ashan did.
Para 23. This is the only paragraph I am underlining. Salmon and jurisprudence explain the word possession is a word of open texture. Its legal meaning has to be ascertained from the context. The property involved in the present case is a open vacant land. Such property is possessed by a person who has control over the same. This control over the property means power to exclude all others. The test then for determining whether a man is in possession of anything, whether he is in general control over it, maybe he is not in actual physical possession. The objectors have led evidence before the executing court to show that after obtaining the recitals in the sale deed, delivery of possession of the property, the names of the purchasers were also mutated in the revenue records. So here, merely because at the time of execution of the decree through Najee, the objectors were not physically present on the property. It cannot be amount to the objector's legal ouster or dispossession. The word possession therefore has to be given contextual meaning on the facts of a particular case and the nature of the property. So my contention would be, the moment the deed is declared as void, because it is a vacant land on which no mutation of the defendant was done, so in a vacant land, I would have the deemed to be in possession, because no possession itself was transferred by a deed which itself was incomplete, which never took effect.
On your behalf and power of attorney was also examined. Whose behalf? His behalf or your behalf? There is one power of attorney.
PW. He is the person to whom it
Third
is said.
party.
Yes, to whom the property, the possession was given. And he has been examined as PW2. He says that I am in possession and I am making consent. This is what his statement is.
Your addition may take 5 minutes.
The learned counsel has also relied upon the judgment passed by the Honorable Supreme Court between bracket 2003 bracket 219 Ashan Devi versus Kulvasi Devi and others. He has referred to paragraph 23 and 22 of the state judgment to submit that the possession in the mutually vacant land is to be reflected. This is on 34.
This is
Anything else on 34?
no. Only last judgment which we had cited was whether how it would take effect, intention of the parties. 2009 volume 4 SCC 193. 2009 volume 4 SCC page 193. This I am also relying for two purposes. This also recorded certain statement in there were certain recitals in the sale deed which the court did not believe it to be true. Merely because it is there in a registered deed, every word it cannot be taken as a sale. Your Lordship may kindly see para 16 onwards. Sale, I'll skip certain paragraph, but I'll only place relevant. Sale is defined as being a transfer of ownership or a price. In a sale, there is an absolute transfer of all rights in the property sold. No rights are left with the transferor. The price is fixed by a contract antecedent to the conveyance. Price is the essence of a contract of sale. There is only one mode of transfer by sale in regard to immovable property or value of so and so, that is by registered instrument. It is now well settled that a payment of entire price is not a condition precedent for completion of the sale by passing title, as section 54 of the Transfer of Property Act defines sale as a transfer of ownership in exchange for a price paid or promised or part paid and part promised. If the intention of the parties was that the title should pass on the execution and registration, title would pass to the purchaser even if the sale price or part thereof is not paid. In the event of non-payment of the balance price of as the case may be, thereafter, the remedy of the vendor is only to sue for the balance price. He cannot avoid the sale. He is however entitled to a charge on such. Normally, ownership and title of the property will pass to the purchaser on the registration of the sale deed with effect from the date of execution of the sale deed. But this is not an invariable rule, as true test of passing of the property is the intention of the parties. Though registration is a prima facie proof of an intention to transfer the property, it is not a proof of operative transfer if payment of consideration price is a condition precedent for passing the property. So here I'll pause. Now your Lordship may kindly take my sale deed where very specifically in the first line itself it has been mentioned that I am in lieu of the consideration the property is being transferred, and that essential ingredient itself was undisputably not true. The answer to the question whether the parties intended to transfer the ownership should be merely by execution and registration on sale deed, or whether they intended to transfer the property to take place only after receipt of entire consideration would depend on the intention of the parties. Such intention is primarily to be gathered and determined from the recitals of the same deed. When the recitals are insufficient and ambiguous, the surrounding circumstances and conduct of the parties can be looked into for ascertaining the intention subject to the limitation placed by section 92 of so and so. In this case, the execution of sale deed is not in dispute. The said instrument was presented for registration on so and so and registered on so and so because the responding vendor appeared before the sub registrar and admitted that vendors had executed the document but refused to make an endorsement to the effect so and so, that he had not received the balance consideration amount of rupees 40. Applying the aforementioned principle, this you have to be applying the aforementioned principle to the facts of this case, we find that the parties intended that the ownership of the property would be transferred to the applicant only after receipt of the entire consideration by the vendor as a completion precedent. The operative portion of the sale deed clearly states that the vendors have agreed to receive 40,000 in presence of the registrar on the date of so and so, and that in consideration of payment to be so made. These lines also, para 21 last 3 lines, and in consideration of payment to be so made, the property was being conveyed to the purchaser. This makes it clear that the title was intended to pass only on payment of the balance consideration amount of rupees 40,000 in presence of so and so. This is supported by evidence of so and so. Therefore, title in fact did not pass either on execution or registration of the sale deed. There is yet another circumstance to show that the title intended to pass only after payment of full price. Though the sale deed recites that the purchaser is entitled to hold, possess and enjoy the scheduled properties from the date of sale, neither possession of the property nor the title deed were delivered to the purchaser either on the date of sale or the so, and then para 25. Therefore, on facts and circumstances of the case, we are of the considered view that the parties really intended that the title or ownership of the property would pass to the purchaser only after payment of full consideration by the so and so. Now, my last concluding submission would be section 54. It says that either paid, partly promised, or promised. None of the conditions are fulfilling in this case. None. It was not paid. It was not paid. And it was not a case that it was promised and not paid. No such recital is there in this. So it only recites that it is being paid by a check number which undisputably that consideration amount was not. So therefore the sale deed was a void document and it should have been declared as a void by the trial court, which has erroneously dismissed most.
The learned counsel has then tried to distinguish the judgment relied upon by the respondent, which is reported in bracket 2009, bracket 6193, and has in particular referred to paragraph 18 onwards. To submit that, in a case where the sale deed itself reveals that the consideration amount is paid, and if it is found that the consideration amount was not paid, then the sale is void. We have submitted that the intention of the party is required to be gathered from the facts and circumstances, and in particular the recital of the sale deed itself. In the present case, the parties intended to transfer the property upon payment of consideration amount. And merely because it was mentioned in the same deed that the possession is being delivered, the same is not conclusive. The possession was to be delivered coupled with payment of the consideration amount which was never received, and consequently the sale deed was required to be declared void. Then he refers to section 54 of the Transfer of Property Act, and he submits that since the sale deed itself revealed that the consideration was paid, and it was nobody's case that the consideration would be paid in future, or it was partly paid and partly to be paid in future. Therefore, none of the three categories regarding payment of consideration under section 54 of the Transfer of Property Act is satisfied in the present case. And consideration having not been paid, in terms of the sale deed itself, the sale deed was
And the defendants have not been able to prove that it was paid, the mode in which it was shown to have been paid.
That's right. It is not in dispute
Not-
that it was not paid through tax.
Yes, yes.
It is not in dispute.
No.
It's all concluded.
Just a little bit of information.
Yes.
Just 2 minutes. One, that his argument that the payment of consideration has not been proved, therefore no part of deed should be relied upon, including a portion of the deed which talks about passing of possession, is a baseless argument and otherwise incorrect. Though it is a registered document, it is a very strong proof, by way of presumption, with regard to passing of at least 2 things. One is passing of checks. Second, passing of possession. So in short, a registered document. Second, section 114 of the Evidence Act, in addition for moment's sake. Just place the section and then see how it aids us. 114. Court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct, and cite one instance of this, and public and private business. The other instances will fall under this, in their relation to the facts of a particular case. Now, so far as public and private business is concerned, that clause will be attracted by plain reading of Exhibit 2. My learned friend has argued that Exhibit 2 and 2 by 3, those letters, are evidences of the fact, implying that possession was not with me. On the other hand, on the contrary, if your ladyship sees Exhibit 2 and 2 by 3 once again, your ladyship will find perhaps that it is contrary. It is showing that possession is mine. Just for a moment, take it, please. And they rely on this document. It is their document. I am relying on their contention. आपको यह सूचित करना है, आपको ये सूचित करना है, जैसे हम लोग की बातचीत हुई, आपने अपना जमीन दलील के माध्यम से मुझे रजिस्ट्री की गई। हम लोगों को तय था कि म्यूटेशन होने के बाद तयशुदा रकम आपको देना है, इसके चेक भी दलील में अंकित कर दिया गया। लेकिन जब हम अंचल अधिकारी के पास म्यूटेशन हेतु दलील को पेश किया, तब पता चला अंचल अधिकारी के पास दलील के लिए कब पेश करता है म्यूटेशन, जब उसको पोजीशन हो जाता है। So, a ladyship would presume that possession was with me, and then only I would. That's the natural human conduct, and that's the course of official transactions also. That one would apply for mutation based on his possession. and DT. Third, with regard to again section 114, it says that registration slip was given to me. The question would be why at all one would after registration of deed give me registration slip and not the mutation. That's again not going in line with the natural human conduct. So if he says that registration slip was given to me, his statement that possession was not given to me should not be believed. Fourth, the conduct, again on possession, these are all on possession. The conduct that he never applied for local inspection. Why the burden of proof was on him because of section 103. Therefore, court should draw adverse inference against him, relying upon the principles of prudence. That the possession was with me and therefore he failed to apply for local inspection. Fifth, Shanti Devi's judgment he has cited, and rightly your ladyship has taken note of the distinguishing feature. When he was arguing in the first round also, I had taken note of that very distinguishing feature and I want to place that possession recovery was prayed for in that judgment. So it will not apply in this case. Another question was put by your ladyship as to whether he is seeking declaration of title. My respectful answer is yes. Indirectly he is. When there is a declaration sought that the title deed is void, the deed by which title has been conveyed is void, it is impliedly seeking or indirectly seeking a declaration that title is not passed on. That means title is with him and not with me. And if that is so, if the ladyship accepts it, then section 34 would be attracted on the principle that what cannot be done directly cannot be done directly. There are umpteen number of judgments on this principle. One of them can be just by way of illustration, Noida versus Noida. But this will apply to paragraph 25. This just a reflection of that settled principle that what can't be done directly cannot be done indirectly. What is prohibited directly, like section 34's proviso prohibits something directly, it prohibits that to be done indirectly also. So somebody not praying for declaration of title and praying for declaring that the title deed is bad will be hit by 34. Next submission is, but this statement will apply only if your ladyship finds that yes, by seeking declaration of title conveyance deed as bad, one is seeking a declaration that my claim of title is bad. His another argument was, my learned friend's argument, that when no payment has passed on, then no right to possession is accrued. Right. I concede. Therefore, if your case is that no payment having passed, no right to possession is accrued, all the more a reason why relief of possession recovery should be sought. And section 34's proviso applies only in those cases in which the relief of possession recovery should be sought. And the relief of possession recovery will be sought only in those cases when the right to possession is not with me. Therefore, that argument cuts his case. The last submission is Asan Devi. Asan Devi was cited on a fact situation when the court had a case where nobody was in actual possession, and therefore issue was how will the court decide? And the court answered saying possession is 9 points in law, and title, therefore the 10th point title will decide whose possession it is if possession is actually law. But here it is not his case that he was not in possession. Here his case is he is in possession, and my case is that I am in possession. And now, most important aspect is that while we have given only oral evidences, and he has failed to introduce certain more evidences which he should have, which he could have and I could have, both have failed. But adverse inference should be drawn against him because it was his burden. Now, the last but not the least, most important thing is that in my evidence, your ladyship will find for a moment just that last thing, your ladyship may just take my deposition. My oral evidence.
Argue it once again.
No, he he argued so much. I'm just saying this last sentence. Last sentence, I've just taken 2 minutes here. It's the last sentence.
What, which evidence?
My deposition, my cross-examination, he starts putting questions to me from paragraph 27 onwards. 29 onwards, ऐसी बात नहीं है. All the suggestions have been given except the fact that position is with him and not. My claim to position has not been denied. Has not been. There is no suggestion given that my statement, my claim of position is false. ऐसी बात नहीं है करके आप देखेंगे. The tenor, I could understand saying that ऐसी बात नहीं है कि मेरा केस सेटअप किया हुआ गलत है. Specifically, he puts all the circumstances, all the aspects in the cross-examination except for position. Therefore, I said you should have a look at it once, but you should already seen. So, and I'm sure you should be seeing everything before coming to the final conclusion. But if your leadership sees subject to correction by a learned friend, not even a suggestion given in my evidence. Correction, subject to correction. पैरा 29 ऐसी बात नहीं है कि कोर्ट में 5 लाख रुपया खर्च करने के बाद पैरा 4 में झूठी है. पैरा 33 ऐसी बात नहीं है कि केस खत्म हुआ 24 34 ऐसी बात नहीं है कि 35 ऐसी बात नहीं है कि शपथ पत्र लिखे हुए पत्र में मुझे जानकारी नहीं है. ऐसी बात नहीं है कि मैंने वो बात का मेरे पास सबूत नहीं है. ऐसी बात नहीं है कि मेरी गवाही है. No suggestion given that my claim of position is false. Since at length my learned friend argued regarding possession, therefore on possession 5 or 6 circumstances are given to evaluation for kind consideration. So in rebuttal, these are the 9 points which I have submitted because this case ultimately is falling much on the factor of possession, coinciding with the principle that possession is 9 points. See, my failure to get mutation done is one thing, but I would go for mutation only after I have a registration document. I will go for mutation only if I am in actual possession.
आप अभी किसका एविडेंस लेकर कर रहे हैं?
शिवजी शर्मा.
शिवजी शर्मा. He has not been given any suggestion regarding possession. Where is this assertion regarding possession?
Paragraph 6 last sentence.
See?
Paragraph 6 last sentence. That was very vital. So I had to support my opinion.
Is there any assertion in his evidence that he was given possession on the date of execution of the scene, which you have stated in your written statement? You have
With
stated in
regard
your
to
written
date,
statement
with
that
regard to date,
on the very
Date
date
of
of execution of safety, you were given
yes,
possession.
paragraph 14.
Yes. Is there any assumption to that? You have referred it, strongly referred to that statement, that on the very date of execution of the safety, you were handed over the possession of the property.
Yes.
any assertion in your
I
evidence?
don't think. No, it's just a 6 paragraph chief.
And
So
so far as
revision
the
is-
other witness is concerned, he is not concerned with multiple possession.
Plaintiff is. So these 9 points which I have given in rebuttal, revision can be taken. Otherwise I can pass on a written note, small, 1 page.
The learned counsel further responded in furtherance to and in response to the submissions made in rejoinder by the plaintiff has referred to the evidence of the sole defendant and has submitted that in paragraph 6 he has made a statement that he was in possession of the property. But during cross-examination, numerous suggestions has been given, but there is no suggestion on the point of possession. However, even in his evidence, however, this court finds that even in his evidence in chief, there is no mention that he was given possession on the date of execution of the same. Though in paragraph 6, he has made a reference that he was in possession of the property.
On that aspect I rely on registered deed.
So
On that aspect I only rely on the registered deed,
that's that's
the stipulation that was.
that's to this, the learned counsel has submitted that on the date, with respect to the date of possession, the learned counsel has only relied upon the registered deed, which itself reveals that on the date of registration, the possession was handed over to the defendant. The learned counsel has further submitted that the plaintiff never asked for local inspection of the property. Rather none of the parties asked for local inspection to find out the actual possession. But it was for the plaintiff to take steps for local inspection, but no such steps having been taken.
Because
No,
of the burden of proof under such a
as the burden of proof was upon the plaintiff that he was in possession of the property, and therefore the plaintiff has failed to establish his case. The learned counsel has also submitted that, as per the stated, 2 aspects are very clear. One is passing of check, and the other is passing of possession. He submits that these 2 aspects were enough to hold that the sale deed was duly executed upon payment of consideration and the possession also passed. The learned counsel has then referred to section 114 of the Indian Injuries Act to submit that the very fact that the defendant applied for mutation itself reveals that he, after having taken possession, went to the authority for mutation and then came to know that the property cannot be mutated in his name as the property was a government. And therefore, and this aspect is apparent from the letters exhibited by the plaintiff themselves to demonstrate that the defendant had gone to the circle office for the purposes of mutation. So far as the judgment passed,
one more thing which here, 114 I had given two arguments. Another one was that if he admits that registration slip has been given,
The
my
learned
position
counsel has
will not
also submitted that the fact that the registration slip was given to the dependent itself reveals that the possession was also.
no, I didn't say that. Why not possession will be given? That itself will not. But then, if everything which is
It reveals
pre-
that this conduct reveals that the possession also must have been.
yes.
So far as the judgment passed in the case of Shanti Devi, Supra is concerned, he submits that in the same case there was also a prayer for recovery of possession. With respect to the judgment passed in the case of Ashan Devi, Supra, the learned counsel submits that the present case relates to the point, relates to the question, also relates to the question as to who was in possession of the property. And in the same judgment, the Honorable Supreme Court has observed that in case of property being vacant, the possession has to be seen from a different angle. But once the parties are in dispute on the point of possession, the evidence has to be seen as to who was in possession of the property. The sale deed itself was enough evidence that the possession was handed over to the defendant on the date of execution of the sale.
It is not even plaintiff's case that there was nobody in possession, actual possession. Therefore, possession should be derived from the title.
He submits that it was not even the case of the plaintiff as to who was in that that the possession is to be derived on the basis of title, and nobody was in actual physical possession of the property. That's it.
The rest is all argumentative, it will be repetition after repetition. He said that since there is no payment, therefore no right to possess. I am saying therefore you should go for recovery of possession. On the promise that I have no right to possess. Yes, so that. The leadership had cited that judgment 2025 indirectly, directly. The leadership like to know about it. Pardon me?
Which judgment? Okay.
No idea.
Yeah.
They are saying
The learned counsel has also relied upon the judgment passed by the Honorable Supreme Court between that of 2011 that of 1965, so very 5/25. To submit that, although there was no plea seeking declaration of title, but still the proviso to section 34 will come into play, as once the sale deed is declared void, the title would naturally go back to the plaintiff.
it amounts to declaration.
He submits that the plea of declaration of the sale deed as void amounts to seeking a declaration of title, and therefore provides in section 34 is very much attractive in this case.
Much obliged.
अच्छा खासा होमवर्क आप हमको दे दिए हैं।
अगर आप कहें इजाजत दे तो हम लोग एक नोट दे सकते
नहीं, नोट में प्रॉब्लम
हैं. Note mutually settled. I know what is the problem.
Note
People
में बहुत ज़्यादा
people introduce new points.
हाँ,
We will not do that.
तब हम बहुत परेशान
No,
हो
we
जाते
can settle each other's notes.
हैं। उसके बाद फिर एक बार और राउंड बोलेंगे बैंक।
ये इनका बना
हम लोग दोनों का
हम
नोट
सारा चीज जो है
आपने नोट कर लिया. And after reading the whole thing, you read it.
But it is a case where
But my learned friend has very fairly said that there are propositions, and rightly so, that not only declaration of title, but all declarations may be hit by section 34 in an appropriate case. So declaration of sale deed as null and void will also fall in that. And it is their case that their suit is declaratory in nature. Paragraph 24, last paragraph of the suit says so. Last paragraph very clearly reverse this. In order to justify their suit valuation, they say
सेक्शन 34 के लैंग्वेज से थोड़ा देखेंगे.
ठीक है, लेकिन मेरा सूट इनके सिर्फ assertion पर नहीं, unless there is a positive finding that I am not,
Yes, your ladyship.
and then I am not.
Your ladyship's judgment.
Really, because there are
Possession will make a lot of difference. If it is held that you is in possession and I am not, then matter it. Then where is the question of section 34 being described? An argument of mutual fairness. I cited judgment in his favor and he cited judgment in my favor.
ऐसा ही है जब आप समुंदर में खोजने जाएंगे मोती तो मोतियाँ मिलेंगी वो किसी के भी पक्ष में रिसर्च करेंगे तो कुछ ना कुछ तो मिलेगा उसमें से कुछ पोर्शन किसी के पक्ष में होता है कुछ पोर्शन किसी
For answer item 1, second appeal 85 of 1994.
के लिखना आपको याद रखना
I will try to be very short statements. But this is a suit for partition by the plaintiff. It is a judgment of reversal. A trial court decree, appellate court not reversed. Can I pass on a single although it must be in the file? Report master. But let us see this plot. It is the case of the plaintiff. Genealogy में कोई dispute नहीं. It is the case of the plaintiff that Sheikh Faga was the common ancestor. He had two wives, Musma Jhalo and Musma Dula. Plaintiffs are from Musma Jhalo and defendants are from Musma Dula. Now notice there are altogether 8 khatas which I have mentioned in the bottom notes. It is admitted case that common ancestor died in 1940, which I have stated, and so far as khata number 36, 11 and 110 is concerned, it is recorded in the name of common ancestor. And other khatas are recorded in name of different defendants. So note, we filed a suit saying that there was no partition with respect to the entire property. The defendant came up and said they took notes plea that there was a case of previous partition with respect to khata number 36, 11 and 110. Although not altogether there are 6 written statements. Few written statements admit that these khatas are joined and is liable for partition. With respect to other khatas, they said it is self-acquired property.
Defendants claim that they are self-acquired.
They are self-acquired property 80, 88, 89 and 90. So far as these khata number 36, 11 and 110 is concerned, they say about previous partition. So not trial court decreed, appellate court reversed.
Decreed with respect to the entire.
Entire. On the ground that notes other khatas which are recorded in the name of different defendants were all on the ground that it is recorded in the record of rights in 1935-36 at the time when father was alive, and they were doing common business, and therefore it has been acquired from joint family fund, although recorded in the name, because that is the case of the plaintiff, and therefore it is said that all khatas, although standing few khatas in the name of defendant, but they were acquired at the time when father was alive, and therefore it is a common property, family property, and therefore they are liable for partition. This was the finding of the trial. The appellate court not reversed this. So far as 36, 11 and 110 is concerned, the appellate court reverses only on 2 counts. First is that there are two sale deeds, Exhibit D and D by 1, executed by plaintiff. They say that this conduct of plaintiff shows that since they are dealing with the property separately by executing sale deed to third party, therefore this conduct of plaintiff shows कि partition हो चुका था. Therefore an inference has to be drawn कि there was a partition. This is one. And the second is that since the parties are living separately, therefore an inference has to be drawn about previous partition. On this note, my case with respect to these three khatas which were recorded in the name of common ancestors have been dismissed, and with respect to other khatas 80, 88, 89, 90, it says appellate court that they were acquired by the defendant and therefore they are not liable for partition. I will not file an IA for additional question of law, that will not be rejected, accepting my one question of law and rejecting my another. So we will be confined only to 36, 11 and 10. So what question of law has been formulated?
36, 11 and 110.
10, yes.
And there is no question of law with respect to 80, 88, 89 and 90.
No, there is no question of law. Although there is a broader question that was framed while admitting the second appeal, which I will try not to argue, so that these khatas also might cover on this question of law. The Lordship may kindly see 16.8.95 order by which it was admitted, whether the inference drawn by the learned appellate court regarding the partition of the property between plaintiff and defendant on oral and documentary evidence regarding separate mess and cultivation between them, between the co-sharers, legal and such inference is available under Hindu law, can be made available under Muslim Mohammedan law also. So, the question of law in my humble submission is that as in Hindu law, the inference that since the parties are living separately, therefore an inference is drawn that there was partition, whether that inference which is available under Hindu law can be made applicable in a case of Muslim law, that only by living separately that inference of previous partition can be drawn in a case of Mohammedan law.
Has any inference been drawn? You see, when this khata number 36, 11, 110
Yes, good.
is entirely the subject matter of consultation.
Yes.
And so far as, if we take it reverse, merely because the parties are living together,
Yes.
can any inference be drawn that all the properties are joint family?
But I say because these khatas are recorded in the name of common ancestor. There is a case of previous partition set up by them saying कि partition हो गया out of 15
ये
acres.
तो self acquired हो ही गया ना
So,
property.
इसका मतलब
80,
हाँ 80 वाला तो हम
self acquired हो
वो तो
चुका है.
self acquired हो चुका. So I am not on that. I am saying only 36, 11 and 110.
Yes,
Those are recorded in the name of common ancestor.
that's right.
And therefore, even if the parties say that we are living separately, as
That
per
makes no
that makes no difference so far as partition is concerned. Now, the case set up by them, कि there was previous partition. On what count they say previous partition? Orally partition हो गया. 1 एकड़ इनको मिल गया जो best of the land था और बाकी 14 एकड़ defendant के पास है. This is their case setup.
ये जो आपका जो stated है,
Yes.
B and D by 1,
Yes.
does it refer to any previous partition?
No.
Or it does not refer to.
It does not refer to any previous partition. It does not say even in the recital कि हमको ये property मिला है और हम इसको partition में मिला और हम इसको बेच रहे हैं. It does not mention that. Therefore, I have given a
Does he mention that it is his property?
sorry,
Does he mention that it is his property?
yes, it is my
That I
property. Because I am a co-sharer. Your lordship is aware that any co-sharer has a right to sell his undivided share, and the purchaser will get what? An undivided interest in the property. So these two counts only, these three khatas have been negated. Lord, I have handed over notes on the last date written submission. If we can just quickly go through up to it. Because this is all the sum and substance of the case. Because Lord, second question was also framed by the Lordships by additional question of law. IA number 12418. This is initially notes 24/9/25 and later on it was modified to 14/10/25. Well, let us see note that also, then we can. But the written submission का होगा तो उसमें नोट्स हम एक ही पेज में कोड कर दिए.
ये किसकी तरफ से केस ऑफ आपका
हाँ,
बाय अपील
by appeal. सॉरी बट ये क्वेश्चन ऑफ लॉ फर्स्ट पेज में होना चाहिए था, लेकिन ये लोग टाइपिंग करके स्टेपल हो जाए पीछे. बट ठीक अपलेट कोड का फाइन थर्टीन पेज द क्वेश्चन ऑफ लॉ.
पेज नंबर से नहीं क्या हुआ ये
Yes, these are the two questions. Lord, second question is whether in spite of clear-cut admission of defendant, but यहाँ पे modify हुआ था defendant में add हुआ था defendant
पहले हम
one,
लोग फर्स्ट सेक्शन
but दोनों एक ही साथ हो जाएगा क्योंकि 3611 और 110 को ही लेके second question.
ठीक whether in spite of
Whether in spite of clear-cut admission of defendant in the written statement filed by defendant admitting that lands of khata number 36, 11 and 110 are joint family property and liable for partition, the suit of the plaintiff would have been dismissed.
एडमिशन बस एडमिशन दिखाइए बाकी काम खत्म.
Not इसमें
हम
खाली
सिर्फ एडमिशन
हाँ
देखेंगे ना
इसमें exactly not इसमें हम खाली एक चीज दिखा कि जहाँ defendant लिखा है ना whether in spite of clear-cut admission of defendant यहाँ पे सर point out किए थे कि altogether 6 written statement है. दो written statement by defendant number 1, 9 and 10 and defendant number 1A to 1C वो add हुआ था modify हुआ था.
हाँ मॉडिफाई
हाँ तो वो उसको खाली वहाँ
इसमें
नोट कर दिया.
डिपेंडेंट की जगह क्या पढ़ना है?
Defendant 1, 9 and 10
1
9 and 10 and defendant 1A to 1C इनके written statement में there is admission to 1C. Yes, this was only modified.
जब ये एडमिशन है तब तो पार्टीशन होना चाहिए. ये एडमिशन को कहीं डील किया
So
इस एडमिशन को कहीं ट्राई
Appellate court.
किया
अपलेट कोर्ट पे तो छुए ही नहीं. अपलेट कोर्ट पे तो खाली वही दो पॉइंट पे ही चले गए. All my lords, appellate court का judgment I will show. He has relied upon the witnesses who were of 5 years and 1 year at that point of time when they say कि previous partition का बात. And there is no document as such. It is a oral. None of the defendant witness have said about any date, month, year or anything that मेरे सामने हुआ है. कोई भी WS मतलब गवाही में ऐसा नहीं है कि कोई पार्टीशन मेरे सामने हुआ है. जो फैमिली मेंबर्स है वो 1 साल और 5 साल के हैं जिन पे रिलाई किया गया है. बाकी जो इंडिपेंडेंट विटनेस है उन लोग बोले नहीं मेरे सामने कोई पार्टीशन नहीं हुआ है, हमको नहीं पता इसके बारे में. लेकिन इन्फ्रेंस जो ड्रॉ कर दिए सेल डीड से एंड लिविंग सेपरेट से, वो इन्फ्रेंस पे जाकर के अपीलेट कोर्ट उसको रिवर्स कर.
सेल्डी देखते लेकिन सेल्डी देखने का स्कोप भी क्या है कंसीडरिंग द नेचर ऑफ डिटेंशन.
यस आई से क्योंकि सेल डीड
It will be stated only on the point of admission.
Yes.
The written statement.
first your lordship then seem towards the plaintiff first that what is the case. But in nutshell I have stated that what is the case. जिनोरी में कोई dispute है नहीं. We have said
सर एडमिशन है क्या आपका? रिटन स्टेटमेंट में एडमिशन है ना?
Pardon?
रिटन स्टेटमेंट में एडमिशन है ना? But this is a joint family property.
This is not admission of contesting dependent. This is the admission of 110,
1, 9, 10.
1, 9, 10.
1A and 1C.
1.
Whom are you representing?
They are represented
आप
by,
किनको represent करते हैं?
they are represented, I am representing respondent number.
The defendant?
But I am representing defendant number, respondent number 10B. And
Respondent ने dependent number
Defendant?
बताइए.
uh,
सर आप बताइए ना आप किनको represent कर रहे हैं? You say that this is
बता-
not the stand of the
बता-
contesting respondent.
बता रहे हो।
यहाँ पर जो 10B and 10C है मेरे पास, वो 10D के लीगल है. अब डिफेंडेंट नंबर 10D.
तो हम नहीं जानते हैं. आप आपके रिटन स्टेटमेंट में ये एडमिशन है कि नहीं है? बस इतना खाली बता दो.
एडमिशन पार्टली है.
उनके
पार्टली है मतलब?
नहीं पार्टली नोट बोला जा रहा है कि वो
Property
तीन
में
खाता वो है,
तीन
तीन खाता वो है, वो 80-80 वाला में नहीं
वो
है.
एडमिटेड ही है।
आप बताइए सर आप किसको represent कर रहे हैं?
हमारे WS में कोई एडमिशन नहीं।
आप कौन से डिपेंडेंट
हाँ,
हैं?
बता दें। डिपेंडेंट नंबर बता नहीं, वन को कर रहे थे तो वन बाद में उधर चला गया।
नहीं उसका 10 बोला.
मैंने ये
1, 9, 10, 1A to 1C.
Yes.
वो 10 के लीगल लेयर की तरफ से हम हैं, 10B और 10C रिस्पोंडेंट है.
आप अपने पेरेंट्स देंगे लेकिन आपसे सिर्फ इतना पूछ रहे हैं आप जिस क्लाइंट को रिप्रेजेंट करते हैं उसके रिटन स्टेटमेंट में एडमिशन है कि नहीं?
इंक्लूडिंग 10 भी था तो 10 का भी पार्टली एडमिशन है.
पार्टली मतलब क्या पार्टली है?
हम पढ़ देते हैं इसको. पारा 6 में जो एडमिशन आया है उसी को हम सीधे
Paradox is that
Yes, written Para 6 is that
रिटर्न
admission.
स्टेटमेंट.
पढ़ी
2 to 8 है।
हाँ, यहाँ पर रिटर्न स्टेटमेंट फाइल किया गया था जॉइंटली 1, 9 और 10 के तरफ से. उनका पारा 6
1 to
में
10 के तरफ से किया गया था।
पारा
बाद
10
में तेरह
that the suit is not maintainable or all the lands mentioned in the schedule of the plan. In fact, the land of Khata number 36, 11 and 110 are common properties of the plaintiff and defendant, and the plaintiffs are settled to their share to the extent of 1/5 and defendants jointly entitled 4/5 share in rest of the lands. They have not interest right, title or possession over the land and are self-acquired property of other co-sharer of their own separate fund as mentioned in the succeeding paragraph. So save and accept the land of Khata number 36, 11 and 110. The rest properties are self-acquired properties of defendants. Who are the heirs of the second wife of that same man.
You are representing dependent number?
2 to 8।
आपके रिटन स्टेटमेंट में
मेरे WS में 1 to 10 था initially, but subsequently 1 and 8, 1 and 9 and 10 have separated themselves by filing a separate application।
नहीं पहले jointly फाइल कर
पहले
दिया गया
jointly
था
file
19 के तरफ से भी,
फिर ये लोग सेपरेट हो गए कि नहीं गलत से हमसे साइन करा लिया।
लेकिन
That was allowed, right?
subsequent written
And court have
statement
accepted all the written statements.
All the legal statements separately।
But the written statement of 1, 9 and 10, it is stated कि इन लोग थंब इम्प्रेशन और वकालतनामा में साइन करा लिए, हमको जानकारी नहीं है और मेरा ये स्टेटमेंट नहीं है और हम लोग WS फाइल है. That was the statement and that was accepted by the court.
So ultimately dependent number 2 to 8 had filed a separate written statement.
Yes.
Where you did not admit. According to you, this property there was a previous partition.
According to us, there were previous partition and the property that is substantial question number 2, recently formulated, has also been dealt with by the appellate court. That is, there cannot be inter-se dispute between the defendants. Because the plaintiff has come forward for partition,
That's right.
not the defendant.
That's right.
1 to 10. 9 and 10.
They are not, see,
There are
one
some,
set of defendants, they say that there was some jointness.
They are claiming
The other
jointness.
set of defendants, they say that.
They are claiming jointness with respect to some property,
Yes,
3
with
property.
Yes, with respect to 3 properties.
Yes,
And according to you, there was a previous partition.
previous party.
And what is the proof of previous partition?
That has
So,
been dealt.
so therefore, there cannot be, there is not absolute admission. So it was to be adjudicated on merits.
Not by all the defendants.
Yes. You see, had it been, because the substantial question of law, second one has been framed by this court.
Yes.
Yes. 14.
But this was initially on 24/9/25 and modified. This is order number 48.
Subsequently.
Order number 48, 24/9/25.
Yes. This we have modified it.
Yes,
here.
yes.
Yes.
This your lordship has modified on 14/10/25 by adding the number of the defendant to clarify that these were the written statements.
What is the proof of partition? So therefore, mere, according to you, mere admission of some of the defendants will have no bearing.
Inter-se transaction, that is the documentary evidence, that has been taken note by the
It
appellate
has
court.
been transferred by whom? Exhibit D and D by 1?
Yes.
Who is the vendor
Appellate-
and purchaser?
Yes.
Are the co-owners vendors and purchasers?
Yes, sir. Therefore, inter-se word has been used.
अगर ये चीज पहले पॉइंट आउट होता ना that only some of the defendants have admitted,
Yes.
then there was no occasion to form that additional substantial.
Yes. But
There
on
was
that
no
day,
occasion to form that substantial question. अगर सबका admission है तो बात दूसरा होता है ना.
तब तो
जब
जजमेंट
आधा
ऑन
लोग का
एडमिशन ही हो
admission है,
सकता
आधा लोग का admission नहीं है तो वो the situation is very very different.
है. तब तो जजमेंट ऑन एडमिशन हो जाता है इनका
बात
ये
खत्म हो
एडमिट हो
जाता
जाता.
है. हाँ, जिस दिन बनाए थे तो यही सोच के बनाए थे ना कि admission है, clear cut admission.
I was not present on that very day.
Yes.
Subsequently, it was amended.
And subsequently it was modified. Admission by one of the co-defendant is of no relevance.
But a defendant from their branch, second wife branch
Branch
entire.
से क्या होता
Once they say, because now lords they are
है? Is there any law that person from the same branch has to take same
no,
stand?
not I say that my case is कि दोनों हम लोग अलग अलग ब्रांच से इसलिए दोनों को पार्टी प्रॉपर्टी मिलना चाहिए. If their branch themselves says and or coupled with the fact that there is no document of any partition, whatever they
Maybe
say
because there is no document of any
Yes.
partition, the conduct of the party is to be seen.
is to be seen.
If somebody is a co-owner of the property,
Yes, but
then why will one co-owner sell it to the other co-owner?
but I have not checked that whether it is
Yes.
between the co-owner
Yes,
or
this is what we need to see.
Yes. Because exhibit D-
Exhibit D and given one. Who has executed exhibit D? Impugned judgment में तो होगा ना?
Exhibit D has been discussed in internal page 27 of the appellate court judgment.
Internal page 27.
running page 96, internal 27,
27 the bottom, my lord.
last 5 lines.
Number 10.
The word begins from in this connection. Exhibit D नीचे से 5वां चट्टान है. हाँ?
Para number 17 है ये.
Yes, lord. Para 17. नोट जजमेंट पे इंटरनल पेज 32 पे है, लास्ट बॉटम में एग्जिबिट डी एंड डी बाई 1 a certified copy of sealed deed. अपलेट कोर्ट का जजमेंट पेज 32 लास्ट.
हो सकता है कि आपका पेज 36 में.
हाँ होगी. तो बताइए.
बट हम बात करते हैं. तो तुम वेलफेयर लिखने के एग्जिबिट डी निकालो, क्योंकि और उस पे लिखा है शेख रहीम, लेकिन शेख रहीम जीनोलॉजी में नहीं है, लेकिन फादर के नेम से टैली करना होगा कि किनको बेचा है. और पेज 32
पेंसिल दीजिए ना मार्क.
ये एग्जिबिट डी Yes. No, exhibit D and D by 1. Have you not got that?
Yes,
हाँ. A certified copy of sale deed executed by plaintiff respondent Sheikh Amruddin and plaintiff respondent Sheikh Bigal.
Exhibit D by 1 are the certified copy.
Yes.
Okay.
A sale deed executed by plaintiff respondent Sheikh Amruddin and plaintiff respondent Sheikh Bigal in favor of Sheikh Rahim in respect of portion of land of plot number so and so, respectively, prior to institution of suit. So, plot जहाँ पे वेंडर का नाम है, वहाँ पे प्लॉट देखेंगे प्लेंटिफ रिस्पोंडेंट लिखा है, जो ऊपर में था, लेकिन शेख रहीम में कहीं डिफेंडेंट नहीं लिखा.
कौन है शेख?
वही तो लोग तारी कर रहे हैं इससे, क्योंकि जीनोलॉजी में कहीं शेख रहीम का मेंशन नहीं.
शेख रहीम कहाँ से?
शेख रहीम लोग व्हाट नाइस
तो इसका मतलब
सीनियर
सेम
फैमिली नहीं हो. जो ये बोल रहे हैं तो इनको लोग सबसे, क्योंकि अगर वो होता तो लोग यहाँ पे मेंशन होता है डिफेंडेंट सो एंड सो, जो ऐसे प्लेंटिफ के बारे में लिख दिए कि प्लेंटिफ रिस्पोंडेंट है, दोनों का बारे में प्लेंटिफ रिस्पोंडेंट शेख अमरुद्दीन एंड प्लेंटिफ रिस्पोंडेंट शेख बिगल. वही चीज शेख रहीम में होता है, इन फेवर ऑफ शेख रहीम ब्रैकेट में करके रिस्पोंडेंट डिफेंडेंट नंबर सो एंड सो, but subject to correction notes by verifying the copy of the sale deed note exhibit D and D.
Exhibit D में in favor of शेख रहीम है ना?
हाँ.
One Sheikh Sharif Mustafa.
Finding 36 पेज पर है एग्जिबिट डी सीरीज के बारे में फाइंडिंग है।
और ये भी फाइंडिंग है कि स्पेसिफिक पोर्शन बस
हाँ, तो सेलेक्टेड होगा तो स्पेसिफिक नहीं रहेगा तो वेक्स
ये शेख शरीफ मुस्तफा कौन है ये? शेख शरीफ मुस्तफा, शेख शरीफ D4 शेख शरीफ
शरीफ इज D4
तो डिपेंडेंट आपस में बेच रहे हैं क्या? प्लेंटिफ ने बेचा है डिपेंडेंट। फाइंडिंग कहाँ है?
पेज 36
नहीं वो रेटिंग अलग अलग है लेकिन
नहीं सर वो ठीक है पेज वहाँ आपका पेज A4 वाला मिल रहा है ना इसलिए ये
Page
आपका
36 in the first paragraph.
You want to see the seedlings? आपको देखना है?
आप सेलेक्टेड पर देखिए
देख लीजिए
हाँ।
आपको seedlings आपको उसी पे
ये
देख लीजिए।
ये तो बहुत नाम से हो सकता है लेकिन फिर भी चेक कर लेते हैं एक बार इंटरनेट चेक
टैग लगा हुआ B
फादर का नाम अगर पता नहीं लगता कि हाँ एक ही फैमिली से है।
And on top of this इसका कोई substantial question of law भी नहीं।
नहीं
This finding that it is transaction between the same families का कोई substantial question of law।
But transaction between the same families कहीं है भी नहीं क्योंकि वह शेख शरीफ प्लॉट जो है क्योंकि but what my instructions is not कि एक उस फैमिली का नहीं है क्योंकि नाम तो प्लॉट्स कॉमन ही बहुत सारा होता है लेकिन इस फैमिली का नहीं है इसलिए हम इसको इससे भी टैली कर देते हैं क्योंकि जजमेंट में भी रेफरेंस नहीं है अबाउट डिफेंडेंट और यहाँ पे
इसमें कोई
फादर
substantial question of law भी तो नहीं है।
हाँ नॉट हम बोल रहे कि इससे जो इन्फ्लुएंस ड्रॉ कर रहे हैं उस पे इससे जो इन्फ्लुएंस ड्रॉ किया जा रहा है मेरे सूट को डिसमिस करने के लिए दैट इज द वन ऑफ द कंसिडरेशन so therefore inference
You see, the only substantial question of law on this point is
Yes.
whether there is admission. बात करना।
so whether there is admission
Admission in the written statement.
yes admission
Yes.
in the written statement
And the contesting defendant says that there is no admission of the contesting.
but let us see the
defendant.
contesting with is WS of contesting defendant number 228 what my
हाँ,
son is
but
representing yes
अगर वहाँ पे आप
Let us-
admission दिखा
हाँ
दीजिए,
नहीं
तो
let us
कोई
see this let us see this because ये बोले कि हम अलग से WS फाइल किए नोट that is additional WS of 228 इनका इनको साथ रिप्रेजेंट करते हैं it is only 11 paragraphs note let me place quickly
Yes, 228 ना?
yes 228
1 to 8, 1 to 10 is to be read as 1 to 10 तो खत्म हो गया।
1 to 10 खत्म हो गया नोट्स अब तो सब सेपरेट फाइल कर दिए
हाँ, 2 to 8
2 to 8 2 है 2 and 3 to 8 मतलब 2 to 8 ही दिखा 2 and 8 उसके बाद 2 इशाक 3 नाम लिखा हुआ नोट्स.
ठीक है, पढ़ने का है.
Yes. The plaintiff in collusion with defendant number 11 to 13 have included the lands of Khata number 19 in the suit for partitioning their sale. The suit is bad for non-joinder of so and so, that the record of right has been as residuary along with Abdul Hakim so and so, that Sheikh Dinu and his brothers on one side and Sheikh Hussaini and others had jointly purchased acquired lands of Khata number 90. But this paragraph is of Khata 90, we can skip that. Now note 4. That Ijmal lands mentioned in Schedule C were later on after RS partition between Sheikh Hussaini on one hand and Sheikh Dinu and his brother on other hand, and Sheikh Hussaini got 250 plot number 259 at Nala plot 1.11 acres, which later on converted into zone of Sheikh Dinu, and his brothers got plot number so and so.
आपको एक बात बतानी है.
Yes, please.
डिपेंडेंट नंबर 228 का प्रिंसिपल स्टेटमेंट पढ़ किसके? क्योंकि सब्सटेंशियल क्वेश्चन ऑफ लॉ
नहीं, हम पढ़ इसीलिए
बनाए नहीं है.
हाँ, नहीं उनका एडमिशन तो हम नहीं बोल, हम तो बोल रहे हैं इनका जो केस है ऑफ दिस प्रीवियस पार्टीशन उस पे, क्योंकि अल्टीमेटली नोट अ सूट फॉर पार्टीशन.
आपका जो सब्सटेंशियल क्वेश्चन ऑफ लॉ है ना,
यस बट
सेकंड वाला तो एकदम मीनिंगलेस है.
but second वाला meaningless नहीं होगा in view of the fact that once there is an admission by any of the defendants, I say, that admitting that the properties are joined with the fact that there is no document of partition of any previous partition, nor there is any worthwhile evidence, I would say, to support the case of previous
Binding
partition.
of admission of one defendant will bind the other.
No, Lord, I say that so far as this aspect of that there is an admission of the defendant from one branch should have been considered by the appellate court in deciding that the appellate court might have rejected their admission. That might be another case. But here, Lord, in spite of clear-cut admission, yes, these khatas are joined, and there is no written statement in toto denying about this fact that these three khatas, which stands in the name of recorded tenant, ancestor, were partitioned, and therefore this is not liable for partition right now because of previous partition. On that context, your lordship will
So
see.
do you want to say that the co-defendants cannot take an inconsistent?
No, I say not they can take, but inconsistent in what regard? If one defendant says, ki, yes, these three khatas are joined, liable for partition, then other defendant can say, ki, no, these three khatas are not joined, there has been a previous partition. There can be an
This is
inconsistency.
the situation.
Yes, there can be I don't
merely
say this.
because some of the co-defendants have admitted that it is joint or
Yes,
whatever.
but,
Then the contesting defendant,
but contesting, he is also contesting. It can't be said in a partition suit that one of the defendant is not contesting. They are also contesting my case.
so ultimately what is to be seen?
But-
The material. you see,
Exactly.
there cannot be any partition
Yes, ma'am.
on admission
Yes.
in such circumstances.
In such a correct. Yes. So I only say
So,
this.
so that admission is of no relevance.
No, because that will your lordship will also see will decide this case of previous partition set up by them with respect to three katas, taking into consideration that even their branch also is admitting that it is joint. It can't be negated कि हाँ because दोनों डिफेंडेंट इंटर से आपस में लड़ रहे हैं कि ये पार्टीशन हुआ है या नहीं हुआ है, एक बोलते हैं जॉइंट है, एक बोल रहे हैं नहीं पार्टीशन हो गया, तो दैट एक को एक्सेप्ट कर ले दूसरा को नहीं करेंगे इन डिसाइडिंग अ केस ऑफ पार्टीशन.
कोई रिटन स्टेटमेंट के बेसिस पे
हाँ.
डिसीजन नहीं हुआ है ना, डिसीजन हुआ ऑन द बेसिस ऑफ एविडेंस ऑलरेडी.
हाँ, therefore I say not. So this fact has also to be taken into consideration.
This fact has no bearing.
By no,
Because plain and written statement by itself is not an evidence.
correct. So not
Whatever has been stated has to be proved by evidence.
yes,
Yes.
yes. So not let us not shut this point, but let us just have it in the back of the mind that there is a admission by few of the defendants with respect to joint property of three khatas. There is
And how
one,
many witnesses were examined from their side?
but their side there are altogether notes 15 witnesses.
Their side means
Defendant.
all the defendants.
All the defendants.
And what about them in particular who are admitting?
But एक ही तरह से गवाही में लगता है. हाँ.
You see, in a case where there is a conflict,
Yes.
maybe between the plaintiff and the defendant, or maybe amongst the defendant, that admission is of no consequence.
But I'm saying, I'm not
And then we have to see how the court has discussed
Yes,
the materials on
exactly.
the
Lord, I'm only saying this. That
and
your lordship
show
will.
me that this finding is perverse because of this reason
Yes.
or whatever.
Now,
Because that is, there is no scope. That admission will have.
नहीं admission पे तो हम judgment बोल ही नहीं रहे Lord. Admission पे तो
लेकिन question of law तो admission पे बना लिए हैं.
Lord question of law क्योंकि there is an
देखिए,
admission.
आप एक
Yes.
चीज देखिए, how serious it is. On the day the question of law was framed initially,
Yes.
right? It was projected as if all the defendants had taken this.
So Lord,
This was the projection. It is not an error of pen.
no,
That
Lord,
was
I'm not
the
saying error of pen. Lord, I have argued before your
Then
lordship.
the
Lord,
entire contours of the argument would change.
Lord, the defendants were there. Sir was not present at that point of time. But Lord, the another counsel was there, and it was argued in an open court. Lord, and I placed that statements.
That's right. But that statement
Yes, Lord.
was seen as a written statement by the defendants. Right? And that is why that particular substantial question of law was made. And subsequently, admittedly, you also retracted from that. They also pointed out that it is admission only in connection with some of the defendants, not with all of the
Yes.
defendants. So that particular, the entire contour of the substantial
Because
question of
not-
law changes.
In my IA also, I have made it very specific points while drafting it for framing question that these are the admission and this defendant written statement, this paragraph it is admitted.
Then that particular substantial question of law should have been withdrawn outright. If suppose
Yes.
you have made this in the IA
Yes.
and in the open court litigation, I'd say that all the defendants have. It's an error, very serious error. Whosoever has committed the error is there on record. That is especially an error. अब आप ये बोल के तो नहीं बच सकते ना कि मैंने आगे में बोला.
नहीं Lord,
तब तो
हम बचने का तो बात ही
स्टेटमेंट
हम बचने का तो बात
तो
हम
आपका
तो
हर
बोल
एक
रहे
स्टेटमेंट हम आपका रिकॉर्ड से
हम तो बचने का बात है हम तो बोल
फिर
रहे
आप इतना सीनियर हो गए तो बाकी लोग
नहीं
तो हम क्या ही
Lord,
एक्सपेक्ट करें.
हम बोल रहे हैं कि whether in spite of clear cut admission of the defendant before, it is not Kim Lord all the defendants because your
All the
lordship
defendants
all
means what?
but so it is not only one defendant not but if your lordship feels कि हाँ क्योंकि अदर इन लोग में आपस में ही कंटेस्ट कर रहे हैं इस खाता को लेके and your lordship will not keep
तो
it
अब तो हम सिर्फ इतना ही देखेंगे कि उनके एडमिशन का क्या इम्पैक्ट है क्योंकि that substantial question of law is staring at me. I have to answer that. I will only see कि उनके एडमिशन का क्या है. Nothing beyond.
ठीक
अब फाइंडिंग जरा देखिए क्या है कोर्ट.
और पैराग्राफ पेज 21 पे जो है पॉइंट्स ऑफ डिटर्मिनेशन
ये जो आपने मुझे दिया इसका फोटोकॉपी आपके पास है.
नोट फोटोकॉपी पेज 32 तुम नोट सेम मैच किया
मैच किया.
हाँ
तो अब
पेज
हमको
32
कौन से
मैच
पेज
किया
में जाना है?
नोट पेज 21 पे नोट पैराग्राफ 14 स्टार्ट होता है पॉइंट ऑफ
point of
डिटर्मिनेशन बॉटम
Yes.
yes whether the case of previous partition between the sons of Sheikh Fagar deceased as set up by defendant appellant is correct. Whether the lands of Khata number 80, note this is of third note, whether the lands of which Khata number Khata 36, 11, 110, 80 and 89 are liable to partition, and if so, what would be the share of the plaintiff? Whether the interveners, defendant, respondent are entitled to better degree of partition, but this is an interstate defendant dispute. Whether an adjudication regarding interstate dispute between the defendant and appellant, so we can all skip this because this is 4 and 5 is between the defendant interstate. So the main issue is point number 1.
Point number 1 and
3, because 3 have been decided in relation to, since I have given a finding with respect to point number 1, 3 has been decided on that day.
no, 3 properties are to be seen. No,
Yes, 36, 11, and 110.
36, 11. So
Yes.
36, 11, 110 is included in Roman 3.
Roman 3, exactly.
What is the finding in connection with point number 1?
Yes. But page 38, just before paragraph 18.
Page 38.
Yes.
Yes.
Just before paragraph 18 note,
Yes.
where it says a same program.
Yes.
Now, 9th line from top notes, in view of the facts.
In view of the
Yes. In view of the facts aforesaid coupled with the principles of law referred to above, I hold as a question of fact that the aforesaid fact conclusively proves that there has been meets and bounds partition of the suit property pertaining to khata number 36, 11 and 10 as alleged by the defendant appellant. Therefore, the conclusion of the learned trial court that there has been no partition by meets and bounds and as such plaintiff respondent entitled for degree of partition is illegal. So it says there was previous partition. Our Lord, let us see notes paragraph 15 onwards how this point have been dealt.
why this khata number 36 again popping up in para number 18?
Because notes in this they say कि इनका जो केस था प्रीवियस पार्टीशन में 1 एकड़ इनको बेस्ट ऑफ द लैंड मिल गया, उसको डील करते हुए.
Then
So now let us see notes point number 1 where paragraph 15 onwards page 22 पे. Okay, how the appellate court have dealt with this.
page number 22.
22 जहाँ point of determination खत्म हुआ ठीक उसके नीचे start.
Yes.
May I place this?
Yes.
Yes. There is no denying of the fact that Sheikh Farah was common ancestor of plaintiff respondent and defendant appellant, and the defendant respondent except the intervener defendant respondent. It is admitted fact that Sheikh Farah had 2 wives, namely Musmat Jhalu and Musmat Lulayat, and Sheikh Chaltu, the father of the plaintiff respondent, is the son of Sheikh Farah, born of his first wife Musmat Jhalu, and Sheikh Farah had 4 sons, namely Dinu, Bukha, Shahadali and Shahbali, born of his second wife Musmat Lulayat. The defendant appellant and the defendant respondent are the descendants of the sons of Sheikh Farah, born from Dular. It is admitted fact that Sheikh Farah died in the year 1940, leaving behind his 2 wives Musmat Jhalu and Musmat Dular and 5 sons aforesaid. That there is also no dispute in respect of the fact that on death of Sheikh Farah, his 5 sons and his 2 wives were his heirs and they have succeeded to the property left by Sheikh Farah as per their respective share in accordance with the Mohammedan law. And the share of 2 widows together of Sheikh Farah was 1/8 in his property as sharer, and 5 sons of Sheikh Farah are entitled to residuary heir in respect of the residue of the properties left by Sheikh Farah. There is also no dispute in respect of the fact that all the heirs of Sheikh Farah were tenants in common in respect of properties inherited by them on death of Sheikh Farah. Even 2 widows of Sheikh Farah were tenants in common in respect of the properties inherited by them as heirs of Sheikh Farah, the deceased. It is also admitted fact that both the widow of Sheikh Farah had deceased their respective sons, and as such their share of each widow aforesaid was inherited by their respective sons. In view of the admitted position regarding genealogy of the parties to the suit and admitted property of Sheikh Farah and his widow, the share of Sheikh Charku comes to 23.6 paise in the property of Sheikh Farah, and remaining 76.4 paise is the share of the 4 sons of Sheikh Farah born from the second wife. There is also no dispute in respect of the fact that khata number 36 stands recorded in RS Khatian Exhibit 1 in the name of Sheikh Fada, as well as in the name of Sheikh Basti, Balkhan, Maltu, Bikku, and Sheikh Zahur as exclusive plots of Khata number 36 were recorded in possession of respective persons aforesaid in the remarks column of RS Khatian, plot number so and so of Khata number 36 recorded in possession of Sheikh Fada aforesaid, and RS Khatian and remaining plot of Sheikh Fada 36 stands recorded in possession of other recorded tenants of Khata number 36. It is essential to mention here that plot number 1231 and so of Khata 36 have not been included in the suit for property. Suit property and plot number has been deleted from the schedule of the plot. There is no dispute in respect of the fact that Khata 11 stands recorded in the name of Sheikh Fada alone, and it contains only one plot having an area of 1.6 acres. Exhibit 1C is RS Khatian in respect of thereof, which testifies the aforesaid fact. Khata number 110 also stands recorded in the name of Sheikh Fada aforesaid, which consists of 4 plots having an area of 3.14 acres. Exhibit 1 by 2 is the Khatian in respect thereof, which also testifies the fact, aforesaid fact. Khata number 88 stands jointly recorded in the name of Sheikh Dinu so and so. Khata number 89 recorded in the name of so and so. Then notes, can we skip this note of different khatas?
Yes.
Yes. Now notes paragraph 17. The plaintiff respondent is that the case of the plaintiff respondent is that the suit property detailed in Schedule B of the plaint consisting of lands of khata number so and so are joint ancestral lands, and the parties to the suit, which are recorded in the name of Sheikh Fada, their common ancestor, or one of his sons, that is Sheikh Dinu, who was in charge of looking after the RS operation and who had bought the lands of khata number 80, 88, 89 and 90 recorded only in his name and that of his brother. The further case of plaintiff respondent is that there has been no partition of the lands in the suit between the parties of their predecessor in interest by means and bounds, and at the time of the and any time, and the parties to the suit are cultivating separate parcel of land as per their convenience, and the parties to the suit are in common. The case of the defendant appellant and the defendant respondent is that oral partition have taken place in the year 1940 between Sheikh Charku, the father of plaintiff respondent on one hand, and Sheikh Dinu, Sheikh Ukra, Shahad Ali and Shahab Ali, 4 sons of Sheikh Fada born from his second wife. On the other hand, after the death of Sheikh Fada, further case of these defendants appellant and the defendant respondent is that in the said partition of plot number 1066 so and so, 24 decimals in west and total area 1 acre pertaining to khata number 36 were allotted to Sheikh Charku in the aforesaid oral amicable partition in lieu of his full share in the property of Sheikh Fada deceased Charku. Got west land and rest of the ancestral property were allotted to the other 4 sons of Sheikh Fada who were in exclusive possession of the same, and in assertion of their own right in the said property. It is also alleged that plaintiff respondent number 1 and 2 who are sons of Sheikh Charku aforesaid have transferred some portion of plot number so and so in khata 36 allotted in their favor to Sheikh Rahim by executing said deed, and have also mortgaged plot number written to Sheikh Suleiman. The intervener defendant respondent who are the heirs of Sheikh Hussaini are recorded tenants in respect of khata number 80 and however supported the case of plaintiff respondent regarding the matter in controversy. Before we scrutinize the evidence on record, it is essential to mention that once again that lands of khata number 11 and 110 stands exclusively recorded in the name of Sheikh Fada, the common ancestor of the party to the suit, and several plots of khata number 36 were recorded in remark column in Khatian in possession of Sheikh Fada, and there is no dispute in respect of the fact that there is also no dispute in respect of the fact that Sheikh Fada died in the year 1940, that is after the divisional survey. It is settled principle of Mohammedan law that the whole of the state of the deceased Mohammedan, if he dies intestate, devolves on his heirs at the moment of his death, and the heirs succeed to the state in tenant in common in specific share. Unlike Hindu law, the state of the deceased Mohammedan, if he has died intestate, devolves on the heirs at the moment of his death. Under Mohammedan law, the birthright is not recognized. There is no joint tenancy in Mohammedan law, and the heirs are only tenant in common. DW14, Sajibuddin, the son of Sheikh Ukla, deceased, in para 1 of his evidence has deposed that the heirs of Sheikh Fada had partitioned the suit property after the death of Sheikh Fada. He has further deposed that all the 5 sons of Sheikh Fada were in existence at the time of death of Sheikh Fada. He has also deposed that the heirs of the 5 sons of Sheikh Faga have also partitioned the property on the death of their respective father. This witness have further deposed that he learned about the said partition from Sheikh Shahan Ali, who is dead. Lord, may kindly make a note. Lord, DW14, what the court is referring to here. But kindly note this, Lord, DW14 has deposed in the year 1987 and his age is 50 years in 87. That means he was born in 1937. And he says,
We are
no,
not going to enter into
no, Lord, I am only saying because these are the evidences which have been taken note of.
evidences. We are not going to enter into this.
Not a person who was only 4 years of
We are
age.
not going, that is not a substantial.
No, Lord, I
We are
say,
not going to enter into
because
this.
Lord, first question of law, Your Lordship will see that on oral and documentary evidence, the question of law refers to this.
Yes, yes, let us see what is the question.
Yes,
You see, either you are shifting from one question to the other.
no, Lord, I say it is because if both are interconnected, because Lord, my case with respect to other khatas, Your Lordship has negated that.
You see, the inference drawn by the learned appellate court regarding partition of the properties between plaintiff and the on oral and documentary
Oral and
evidence
documentary.
regarding separate mess and
Yes.
cultivation. Yes. It is only with regard to separate mess
Yes,
and
yes.
cultivation.
Therefore, I say, Lord. So he says कि partition,
Partition होना अलग बात है, separate mess and cultivation होना अलग
हम
बात
तो यही बोल रहे Lord
Yes.
कि partition अगर हुआ तो ये बोल रहे हैं कि इन लोग का partition हुआ.
Between the co-sharers and such an inference is available under the Hindu law can be made available under
Therefore, I say, Lord, कि Hindu law में जो inference है about separate mess and cultivation.
Hindu law में क्या inference है about separate
But-
mess and cultivation that it is still joint.
It is still joint till it is not partitioned.
Yes.
Same Lord in Muslim law, because once the father
How
dies,
will it make a difference?
I say it will not make a difference. I say that taking into consideration that only living separate as per convenience does not mean partition. And executing two deeds which does not refer about any previous partition does not mean partition. And Lord, the consideration of this defendant 14, who was only Lord 4 years at that point of time when it is said कि father के मरने के बाद partition हुआ.
कब हुआ बाप फादर के मरने
ये
के?
बोले हैं Lord, देखिए
फादर के मरने के कितने दिन बाद हुआ?
वही तो इस पे किसी का नहीं है.
उसने बोला तो हम कैसे inference draw करें?
Therefore I say कि therefore inference has to be drawn that there was no partition.
फादर के मरने के बाद partition हुआ.
हाँ
But he is not saying कि कब partition.
हाँ ठीक है.
So therefore, how do I draw an inference that he is talking about partition in the year 1940?
Yes. तो फादर देख हम तो ये बोल रहे हैं Lord कि partition हुआ ही नहीं. Therefore I say कि ये बोल रहे हैं कि फादर के मरने के बाद हुआ. इनका बाकी जितना भी हम गवाही दिखा देंगे कि इनका कोई भी गवाह ऐसा कोई ना डेट के बारे में बोला है, ना साल के बारे में बोला है, ना मंथ के बारे में बोला. इनफैक्ट इनका गवाही है जो बोल रहा है कि हमको पता नहीं है पार्टीशन के बारे में. And that is the consideration by the appellate court. I am only requesting your lordship to kindly make a note that DW14 was only 4 years at that point of time.
At what point of time?
When he deposed, when he says about death of father, because
When did he depose?
but he says in 87 he deposed, he was 50 years. So 37 he was born. So once he was born in 37, till 1940 it says Sheikh father had partitioned. He has further deposed that all 5 sons were in existence at the time of Sheikh. He has also deposed that heirs of the 5 sons have also partitioned the property on the death of their respective father.
Yes.
Yes.
On the death of the
Therefore I say Lord कि यहाँ तो कोई specific है ही नहीं कि किस समय oral partition हुआ. Therefore a person who comes forward and pleads a case of previous partition has to prove his case of previous partition by giving कि हाँ इस तारीख को हुआ, इसके सामने हुआ, ये वहाँ प्रेजेंट थे ओरल में. अगर रिटन है तो रिटन डॉक्यूमेंट देते, अगर ओरल है तो गवाही देते कि हाँ ये आदमी थे, पंच के सामने ओरल पार्टीशन हुआ. So this is one TW14 and he is son of not one of the defendants. Now let us see DW15. He is son of defendant number 2. Lords. Sorry, defendant number 1, DW15. Sheikh Imdad Hussain is the son of Shahad Ali, deceased. He has deposed in para 1 of his evidence that lands of Khata number 36, 11 and 110 have been partitioned. DW14 and 15 have further deposed in their evidence on oath that lands of Khata number so and so are self-acquired property of defendant respondent in which the plaintiff respondent have no interest. It is essential to mention here that there is interstate dispute between defendant appellant and plaintiff respondent regarding acquisition of lands of Khata 80. So what we can just skip that because these deals with other Khatas. Now let's kindly take notes. Page
80 also belong to them.
80 notes is recorded in their own name. So only 3 Khatas, 36, 11 and 110 is recorded in name of Sheikh Father. क्योंकि वो जो जिनलॉरी वाला पेज दिया था नोट उसमें हम मेंशन कर दिए कि किसका किसके नाम से मेंशन. नोट काइंडली टेक नोट्स then page 31 where he considers about the witness of DW4, 5 and 6.
You see, DW14 के evidence का cross examination भी देखा है.
हाँ ठीक है.
Page
अब
30 में.
तब हम पढ़ते हैं.
हाँ.
Let us see. Khata 80 I will dilate later on its appropriate place. DW14 in para 16 of his cross examination has however deposed that there is no paper evidencing the fact of partition which has taken place in the year 1941. He has also deposed that he can't say the date, month and year of the said partition as well as the name of the person in whose presence the partition in question had taken place. DW14 has further admitted in para 16 that Jamabandi of lands of Khata number 36, 11 and 10 has not been separated in accordance with the said partition. In para 17 he has of his cross examination DW14 has further deposed that Sheikh Charku, ancestor of plaintiff respondent, has got 1 acre of land in the said partition. In para 21 of his cross examination DW14 again has stated the fact there is no paper evidencing the fact of partition and the Jamabandi has still not been separated. DW15 in para 8 of
DW14 की evidence में तो कोई believe नहीं करता.
हाँ हम वही बोल रहे हैं.
नहीं कर रहा है ना.
नहीं ये कोट कर रहे हैं कि यार चीफ में क्या बोले और क्रॉस में क्या बोले. तो नोट DW14 का एविडेंस में देखिए हम नोट कि इनके एविडेंस में ना ये बोले हैं कि कोई पेपर के बारे में कोई डेट कोई
डेट 1941 बता.
41 कि फादर का डेथ के बाद.
नहीं हाँ.
फादर का 40 में फादर का डेथ हुआ उसके बाद पार्टीशन. अब नोट 15 करेगा. DW15 in para 8 of his cross examination has also admitted that there is no paper of partition evidencing the fact of partition of the lands of Khata number 36, 11 and 110. He has further deposed that the Jamabandi of lands of the aforesaid Khata is still continuing in the name of Sheikh Father. His evidence is further to the extent that he has no objection if the lands of Khata number 36, 11 and 10 is repartitioned between the parties to the suit. His evidence is further to the effect that lands of Khata number 80, 88, 89, 90 was not subject matter of partition in the said partition. So not DW15 also, same notes, no document, no date, no. Now DW4. DW4 has deposed in para 4 of his evidence that the land was partitioned between the sons of Sheikh Father within 1 or 2 years of the death of Sheikh Father. In para 20 of his cross examination, he has deposed that he has not seen any paper of partition in question and the said partition has not taken place in his presence. He has also deposed that he cannot say about the date, month and year of the partition in question. This witness has however in para 20 admitted that Jamabandi is still continuing in name of Sheikh Father. This is DW5. DW5 in para 12 of his cross examination has deposed that the partition in question has not taken place in his presence and he has not seen any document evidencing the fact of partition. DW6 in the concluding portion of para 11 of his evidence has deposed that the partition in question has not taken place in his presence. Now note PW. So note altogether 5 DWs, 14, 15, 4, 5 and 6, none of the defendant witness have stated about any date, month or year of partition. Even it is admitted that still not the Jamabandi is running in the name of common ancestor Sheikh Faga. That notes I have tried to highlight in my written notes of argument also. Now note PW6 is being considered. PW6, son of Sheikh Charku, the deceased, is the plaintiff respondent in this case, and he has deposed in para 4 of his evidence that entire suit property is the property of Sheikh Faga deceased and the khatiyan in respect thereof has been prepared in the name of Sheikh Faga deceased, and the entire land is still joint. In para 11 of his evidence, he has deposed that the parties to the suit are cultivating the suit lands as per their conditions. In para 25 of his cross examination, he has deposed that the parties to the suit jointly make the payment of rent of lands of khata number 36, PW1 in para 3, PW2 in para 6, PW4 in PW3, PW4, PW5 in para 2 each have deposed that the suit property is joint and no partition in respect thereof has taken place between the parties to the suit. PW6 has further deposed in para 11 of his evidence that the parties to the suit are separately cultivating the lands as per their convenience. In para 18 of his cross examination, he has deposed that all the three sons of Sheikh Charku are living separately with each other since long. PW6 have further deposed in para 18 and 19 that he and his brother Amaruddin have sold some of the lands in his possession which originally belonged to Sheikh Faga to some person. Exhibit D and D/1 are certified copy of sale deed executed by plaintiff respondent Amaruddin and plaintiff respondent Sheikh Bigal in favor of Sheikh Rahim in respect of portion of lands of plot numbers so and so respectively, and that is prior to institution of the suit. PW1 in para 6 have deposed that the parties to the suit cultivate the suit land separately. Para 7, PW1 has further deposed that the parties to the suit have their separate residence and mess. PW2 in para 11 has deposed that Sheikh Charku was living separately from his father Sheikh Faga and the house of Sheikh Charku was also separate. He has further deposed that Sheikh Faga has given some lands to Sheikh Charku for separate cultivation and Sheikh Charku was doing cultivation work on the said land. He has further deposed that after death of Sheikh Faga, all 5 sons of Sheikh Faga started doing cultivation work separately. However, this witness has an audacity to depose that they were doing separate cultivation on separate parcel of land without any effective partition. Since then, they are cultivating the land in the very manner. PW3 in para 11 have also deposed about separate mess and cultivation. Sheikh Charku as well as 4 sons of Sheikh Faga deceased, one of his second wife. He has further deposed that since then the cultivation and mess and residence are separate and he is seeing them from such time of his post. This witness is 70 years old. PW4 in para 6 has deposed that after 4 years of the death of Sheikh Faga, all his sons became separate in mess, fund and cultivation. PW5 in para 9 has deposed that the parties to the suits are separate, cultivating the lands 1 or 2 years after death of Sheikh Faga. TW3, 6, 7, 8 in their evidence on the oath have deposed about cultivation of defendant appellant and defendant respondent and their predecessor in interest separately in certain specified plots. In this connection, para 2 and 3 of DW3, para 2 and 3 and 4 of DW6 and 7, each para 2 and 3 of DW8 may be referred. It is therefore appears from the evidence referred to above that Sheikh Charku, the son of Sheikh Faga, born from the first wife Dinu, Chandali so and so, born from second wife, in the separate cultivating possession of specific plots exclusively as soon as after death of Faga, and Sheikh Faga deceased thereafter. The defendant and the aforesaid 5 sons of Sheikh Faga deceased are continuing in cultivating possession of these plots. It further appears from the evidence aforesaid that there is no paper of partition evidencing the fact of partition between the parties to the suit, and the Jamabandi is still continuing in joint between the parties in the name of Sheikh Faga in respect of lands of khata number 36, 11 and 10. It further appears in view of the fact referred above that the plaintiff respondent has dealt with the lands in their exclusive cultivating possession by executing 2 sale deeds exhibit D series. Relying on the case law reported in the learned advocate of the defendant appellant has submitted that one of the essential ingredients for grant of a decree is proof of unity of title and possession, and inference of previous partition can be drawn only on basis of various circumstances, and such separate residence, possession of payment of rent, etc. And this feature is primarily applicable in Hindu law. Hindu joint family can be applicable for similar inference of previous partition of a Muslim family as well. The learned advocate for the defendant appellant has further placed reliance on the case law reported in so and so, in which it has been held that where the parties have been in possession of land exercising ownership over separate block of land over a long time, the court might well presume that these lands have already been divided and the rights of the parties as defined with regard to them in such manner is precluded their being repartitioned. In this connection, the learned advocate for the appellant has also referred to Exhibit D, whereby the specific portion of plot has been transferred by executing sale deed by plaintiff respondent so and so to 1/3 portion of the said plots have been left which was in the share of
It
the
says so and so much.
Yes. Achha, ठीक. Exhibit D series where the specific portion of plot number 1066 and 1067 have been transferred by executing sale deed by plaintiff respondent Sheikh Beagle and Sheikh Amuddin, and 1/3 portion of the said plot have been left which was in the share of the plaintiff respondent Sheikh Ismail, son of Sheikh Chattu. It has also been submitted that the learned advocate learned court didn't construe the Exhibit D series in proper perspective. It has also been submitted on behalf of defendant appellant that execution of the sale deed by the plaintiff respondent, the most material exhibit in this case, which shows the exercise of right of ownership on specific plots by the plaintiff respondent, which shows that there has been partition of the suit property as alleged by defendant appellant. It has also been submitted that separate mess, residence and cultivation of parties to the suit on specific plot also support the case of partition as alleged by defendant appellant, and the continuance of joint jamabandi can never be itself be a ground to disbelieve the case of partition as alleged by the defendant appellant. The case law reported in 1936 Patna so and so also lays down the proposition of law that where a party have been in possession of exercising rights of ownership over separate block of lands for a long time, the court might presume that these lands have already been divided and the rights of the parties defined in regard to them is in such a manner may be precluded from their being repartitioned. Exhibit 2, the survey parcha, has no relevancy in this case. It is not admissible in evidence and recording of fact jointness where therein between the parties in respect of the lands in the suit mentioned. Therein has no bearing regarding the matter in controversy and it does not at all help the case of the plaintiff respondent. Furthermore, dispute regarding deeds and bound partition and family arrangement regarding lands of Sheikh Fada, son of soon after his death between defendant appellant is of no help to promote the case of the plaintiff respondent in respect thereof. In view of the evidence on the record referred to above, it is crystal clear that the plaintiff respondent and defendant appellant have their separate mess, separate residence, separate cultivation, possession of the lands in question, and separate residential house soon after death of Sheikh Fada. It is further appears that plaintiff respondent have also separate dealing with the property in view of their exclusive possession by executing sale deed. In view of the fact aforesaid, coupled with the principles of law referred above, I hold a question of fact, and this is the finding. So, note, in my humble submission, note, the court considers the evidence of few of the defendants, 14, 15, 4, 5, and 6. They are absolutely ignorant about any partition. Rather, they say ki jamabandi joint, and the court considers this, but only Lord relies upon or Lord goes in favor of the defendant on two counts, that is sale deed and separate residence. But living separate does not mean partition. And executing joint family property sale deed notes in favor of any party will not have an influence of partition till it is proved beyond doubt by leading oral evidence and documentary evidence. But where does the evidence of DW4, 14, 5, 6 refers to about any previous partition? Rather, they say that it has not been made in my presence, jamabandi is joint, I have not seen the paper, I don't know about date, month, year of partition. So, not a party who comes forward and pleads a case of previous partition, the burden is on him to prove his case of previous partition. Let us see, Lords, since there is no documentary evidence, let us see the evidence one by one of how
No,
the
we have seen.
yes,
ये बताइए.
yes, Lords.
You see, what is the import of the first substantial? Whether the inference drawn
Yes, whether the inference drawn by the learned appellate court regarding the partition of the properties between plaintiff and defendant on oral and documentary evidence regarding separate mess and cultivation between the co-sharer, legal and as such inference is available under Hindu law can be made available under Mohammedan law also. So, Lords, what I understand in my humble submission is that in
आप बनवाए ना आप बताइए इसमें क्या लिखा है? So that your instance is substantial question of law has been framed, you just tell us.
yes, not that
Mere separation in mess and cultivation, etc.
yes,
does not call for any inference that there was a previous condition.
yes,
Right? By means and bounds.
that means
Right? There has to be a positive action by means and bounds so far as partition is concerned.
yes,
Right? The same principle is applicable in Mohammedan law.
yes, it is
So
applicable.
why this question of law? And has the court drawn any such kind of, the court is coming to a finding that they are separate in mess, they are separate in cultivation.
Yes, Lord. The court says only that since separate mess है, अलग रह रहे हैं, and जमाबंदी joint भी होने से कुछ नहीं होगा और that relies upon exhibit T to seal the dual and negates the case of partition. So, Lord, my submission would be that once the defendant have come up with a case, but my case is very clear so far as these three khatas are concerned, not with respect to other khatas. These three khatas, it is joint property recorded in name of father. Father died, there was no partition, still Jamabandi was joint. We were paying rent in the name of ancestor only, which shows that there was no partition.
That's right. Once a respondent आपको क्या बोलूं? जमाबंदी was still joint.
Mohammedans are not supported to be joint having nuclear, joint nuclear.
They need not. We are not bothered about nucleus. So nucleus का कहानी तो खत्म हो गया because वो जो self-acquired
ठीक है,
property है वो तो story
ठीक है.
over.
Now that he is confining his prayer with
36,
respect.
11 and 110.
Now he is confining his prayer with respect to
Three properties.
three khatas. Now my submission in this regard is that a partial partition under Mohammedan law is not permissible under law.
So partial partition का कोई बात
Partial
नहीं है.
partition with respect to certain property and certain left joint is not permissible.
No, there is no property which is left joint. Which property is left?
Now let's kindly have a look to the copy of plate itself. Altogether 7 or 8,
Yes.
5 khatas have been.
5 khatas are there. The rest of the khatas are self-acquired property. It is not that it is not a. It was previously
Partition has been sought for with respect to
36, 11, 110, 80, 88, 89 and 90.
yes, that has been quoted in the
Yes.
genealogy given by my
Yes,
friend.
yes, yes. So the remaining are concerned, those are the self-acquired properties specifically recorded in individual name.
Now let's kindly have a look to running page 88, internal page 90. Is para
16 votes.
That's 16 of the.
Appellate court.
Appellate. Certain plots have not been included. Para 16,
Para 16.
The 9
Para 15, para 16.
there is also no dispute. Let me take help of my friend.
Yes, yes. So what do you want to say? First tell us what do you want to say.
Regarding
Where certain plots have been left out of partition.
Which plot has been
Yes, yes. Hello?
1231 and 1236 of Khata number 36, Lordship.
Therefore, it is partial partition. Hmm. And it has been deleted from plot somewhere. Yeah. And
Plot number 1250 has been deleted from the schedule of the suit property.
Therefore, it is partial partition with respect to certain properties.
plot number 1231 and 1236
Yes.
and plot number 1250. This is in Khata number 36.
Therefore, I submitted that partial partition in Mohammedan law is not permissible. That means I am here. Blood, I am referring this civil appeal number 7008 of 2008, para 16.
Very Lordship. Before adverting to the rival contentions of the parties, it must be kept in mind the principle that ordinarily a party should not be prejudiced by the act of court. It must also further be borne in mind that in a partition suit, where both the parties want partition, defendant may also be held to be a plaintiff. Ordinarily, a suit for partial partition may not be entertained, and the parties have brought on record by way of pleadings and other materials that apart from the property mentioned by the plaintiff in his claim, there are other properties which could be subject matter of partition. The court would not be entitled to pass a decree even in relation thereto.
Therefore, my first submission is that the suit itself is not maintainable. And this concept is very old, blood. 1992 Allahabad, the year 1992 Allahabad, page 250. Relevant paragraph is paragraph 5 of the
The plaintiffs
Was there any issue framed on partial partition?
No,
Which
not
was
that. Maintainability. It is the crucial issue.
ऐसा तो कुछ substantial question of law ही नहीं।
नहीं बना.
तो
Now
उसका
let,
क्या?
I am coming to this first substantial question of law.
आप substantial question of law
Yes.
ऐसे open ended argument second में तो नहीं था, उनको भी नहीं करनी का, आपको भी नहीं करनी।
नहीं, वो तो सेकंड वाले पर तो आर्गुमेंट करने का प्रश्न ही नहीं पैदा होता है.
उसका तो कोई मतलब ही नहीं है, क्योंकि वो जो आप partly अगर मान लीजिए आधे लोग admit कर रहे हैं, आधे नहीं admit कर रहे हैं, it is absolutely fluid.
And that has been discussed by the appellate court that inter-se dispute between defendants cannot be मतलब decided in this suit.
That's right. वो तो उनका तो substantial question of law का कोई मतलब नहीं है.
Now, so far, applicability of Hindu law is concerned, that
So
has been
इस substantial question of law में क्या कहना चाहते हैं? What is the meaning of this substantial?
हम जाकर समझते हैं कि इतना कहने का मतलब है कि हिंदू लॉ का जो कंसेप्ट है, लिविंग सेपरेटली बेस एंड कल्टीवेशन एटसेट्रा, विल नॉट कंस्टिट्यूट पार्टीशन. मेरे समझ से यही मतलब है.
हिंदू लॉ का जो concept है living separately in
For a
mass
long
and
time.
cultivation,
Yes,
right, does not draw an inference of partition,
partition.
right?
And whether that is applicable in case of Mohammedan or not.
So in Mohammedan law also, if a person is living separately in mess and cultivation, right, and the property is standing in somebody else's name and the joint ownership, or maybe a common ancestor, तो भी इसको presumption of partition को यूज है.
Presumption of partition, they are living separately since long, 1940-41. And therefore, when the suit itself is barred by limitation, they are claiming separate inter-se transaction between parties.
Interstate
These are
transaction
the-
नहीं है between the parties.
Inter-se transaction तो हुआ है, exhibit D series.
Interstate transaction तो नहीं पता चल रहा है ना किस कौन क्या रिलेशनशिप है, ऐसा कोई फाइंडिंग नहीं है कि interstate transaction.
नहीं, फाइंडिंग तो अपलेट कोर्ट का है ही.
Interstate transaction between the parties. कहाँ
That is
है
the
appellate court का
exhibit D
finding?
series जो अभी रेफर हुआ था.
नहीं, interstate transaction between the parties बोल के नहीं है. There are transactions, there are sale deeds executed
A
by the
specific
plaintiffs.
transaction has been done by the party.
By the plaintiffs.
Vegan is one of the party.
Yes, the sale deed has been executed by one of the parties. That's it. But interstate deed dependent उससे खरीद ले रहा है property, ऐसा तो नहीं. और ऐसे interstate transaction का कोई finding भी नहीं.
ठीक है, उसका डॉक्यूमेंट देख लें. क्या देखें? One judgment has been quoted, 1993 year, in para 17 के एंड में. Page 35 from very first line. 93 volume 1 page.
1984 period here.
93.
93 one period. What is it?
What?
It further, from the beginning of that page I am reading, it further appears from the evidence aforesaid that there is no paper partition evidencing the fact of partition between the parties to the suit and Jamabandi. And Jamabandi is still continuing joint between the parties in the name of Sheikh Vaga in respect of the lands of Khata 36, 11 and 110. It further appears in view of the facts referred above that the plaintiff respondent had dealt with the lands in their exclusive cultivating possession by executing two sale deeds, Exhibit D series. Relying on the case law reported in 93 1 PLJR 172, learned advocate for the defendant appellants has submitted that one of the essential ingredients for grant of decree is proof of unity of title and possession, and inference of previous partition can be drawn only on the basis of various circumstances such as separate residence, possession, on payment of rent, etc. And these features, primarily applicable in case of Hindu family, can be applicable in similar inference of previous partition of a Muslim family as well.
But this is the judgment.
This is, yes, this is similar substantial question. First option.
ये 93(1) के है ना?
Yes.
हमें
कल सुनेंगे सर, कल लिखाएंगे इसको. The arguments have been made to oppose this case for further hearing.